Susunod na po ang The Chief Justice on Trial, the GMA News TV special coverage.
At yan po ang siksik na impormasyong hatid namin. Ako po si Connie Season.
At ako naman po si Ivan Mayrina mula Lunes hanggang Biyernes, tuwing 1:00 ng hapon.
Kasama nyo kami sa serbisyong totoo.
Ito ang mas pinalakas na
On Call!
Solve ka sa panayam at agarang serbisyong hinatid ng On Call at Sunsilk Smooth and Manageable.
Isa pong makasaysayang araw, mga igan.
Sa kauna-unahang pagkakataon, magbababa ng hatol ang impeachment court sa punong maestradong nasasakdal ng betrayal of public trust at culpable violation of the Constitution.
Matapos ang 43 araw ng paghahain po ng mga testigo at ebidensya sa pinakaunang full-blown impeachment trial sa Pilipinas, masasaksihan na po natin ng buong bansa ang desisyon ng Senado. Guilty ba or not guilty si Supreme Court Chief Justice Renato Corona?
Magandang hapon po, ako po si Vicky Morales.
Ako naman, Arnold Glavio. Ito ang The Chief Justice on Trial. Mga igan, patuloy tayo magbabantay sa mga pinakamaiinit na pangyayari sa Senado at mag-uulat po mula ron ating kasamang si Joseph Morong.
Nakatutok naman sa kampo ni Chief Justice Renato Corona sa The Medical City sa Pasig, si Lia Manyalak del Castillo, habang si Mark Salazar ang nakaantabay sa mga kilos protesta sa Pasay, kaugnay pa rin po ng impeachment trial.
Dito naman po sa studio, pagyayamanin ni Professor Rowena Daroy Morales ng UP College of Law yung ating pong pag-unawa sa ibababang hatol ngayon ng impeachment court.
Magandang hapon po, Professor Morales. Last day.
Good afternoon.
Good
Historic.
afternoon. Yes.
At mamaya, Vicky,
Makakasama natin si Dean Pacifico Agabin, ang dating dekano ng UP College of Law. Mamaya po yan.
puntahan muna natin po ang Senado. Si Joseph Morong po ang nakabantay doon. Joseph, kamusta atmosphere dyan?
Excited. Ang dami ng tao sa gallery. No? This is a very historic moment sa kasaysayan ng ating bansa. Nakatapos tayo ng isang impeachment trial. Ngayon, ayon dito kay Senate Majority Floor Leader Tito Soto, no, ay handa na yung mga senador sa kanilang magiging boto ngayong hapon. No? And most of them have already made up their mind. Tatawagin alphabetically yung mga senators natin. Tapos kahuli ang boboto si SP Enrile bilang siya yung Senate Presiding Officer. Bibigyan ng 2 minutes yung mga gusto magpaliwanag ng kanilang boto at yung order or yung verdict will be, according to Senator Soto, will be immediately executory at yung notice of whatever decision that the Senate comes up with today ay gagawin at i-issue sa mga concerned parties. Narito ang pahayag ni Senator Soto.
The Constitution provides for that. You know, you go through what it says. It says kung acquittal, that's it. No? Kung conviction, removed.
Convicted,
Not siguro. That is the spirit of the Constitution.
Pero sir, wala nang formal notice.
No, magkakaroon ng letter ang Senate President informing the proper authorities of what the decision of the court will be. Immediately. Mamaya din yun. Oo, today din. Right after the verdict.
Sabi pa ni Senator Soto, yung sinasabing Enrile Block, no, yan yung block nitong si SP Enrile that carries, ang sabi dito ay 4 na boto, ay hindi raw boboto ng pare-pareho. At ayon dito kay Senator Soto, ay ayaw daw impluwensyahan ni SP Enrile ang boto ng kanyang mga kasama sa Senado. Muli si Senator Soto sa kanyang pahayag.
Block voting ba yung gagawin ng Gang of Four?
Hindi. The Senate President, I don't know what the outcome will be, but the Senate President has made it very clear to us and to others who he talked to that his vote is his vote. He is not influencing anyone. He does not want to influence anyone, even the so-called Enrile Block.
Igan, Vicky, just as a measure ng interest kahit ng mga ordinaryong mamamayan natin, kanina sa labas ng Senado, merong isang alin na galit dahil hindi raw siya nabigyan ng ticket. Kanina pa siyang mga alas 10 o alas 11 ng tanghali kanina at nag-aabang nga siya para makapasok. Kaya lamang ay hindi siya nabigyan ng ticket ng Senate, kaya hindi siya pinayagang makapasok sa loob. Although in the past few days ay nakapanood na rin siya ng Senate proceedings. No? Ayan, siya si Lori Bivar. Sabi niya sa atin kanina, siya ay cancer patient, hindi siya nagtatrabaho ngayon, pero sinadya niya itong Senado dahil gusto niyang manood sa desisyon ng Senate Impeachment Court dun nga sa kaso ni Supreme Court Chief Justice Renato Corona. Samantala, kasama natin sa mga oras na ito ay itong tagapagsalita ng prosecution at saka ng defense panel. Kasama natin si Quezon Representative Erin Tanyada at si binibining Attorney Karen Jimeno. Unahin po na natin ang defense muna siguro. What are your expectations today?
Well, in terms of the decision, we really have no clue how the senator judges will decide in this case or how many votes for acquittal or conviction. But for us, we are leaving this to the wisdom of the senator judges and the impeachment court.
How about the prosecution side, sir?
Well, alam mo, Joseph, ito ang 44th day. Ang gusto namin po dito 4 times 4 para 16, hindi 4 plus 4, 8. Dahil kung hindi po namin makukuha yung 16, syempre hindi makukonvict ang ating punong maestrado. At kung 8 ang makukuha nila, ganun rin po yan.
After the Senate has issued the verdict, what now for CJ first?
Well, it depends.
Yeah.
Is it acquittal or conviction? Para sa amin, kung ito ay isang acquittal, then well and good for Chief Justice Corona. Kung ito na may isang conviction, then I think we will have to consult him kung anong gusto niyang gawin afterwards.
Is he watching the proceedings now?
Yes. Nung nakausap namin siya nung huli, gusto niya sanang pumunta dito personally for the judgment. Kaya lang, hindi siya nakakuha ng discharge from the hospital. Nandun pa rin siya sa medical city ngayon. At palagay namin, hindi naman kinakailangan to undergo a risk na pumunta pa siya dito because hindi to katulad natin na nag-sign siya ng waiver even against the advice of the doctors kasi kailangan talaga siya dito for cross-examination.
Okay, sir. Kayo, halimbawa, manalo or matalo? Paano ang scenario?
Well, tatanggapin po namin sa prosecution kung ano man ang magiging hatol ng ating senator judges dahil kami naman po ay matutuwa na nasundan ng proseso. Ngayon, kung ano ang magiging hakbang po ng House leadership, kung yan po ay acquittal, pag-uusapan po namin pag dating po ng Disyembre. Yun po ang pagtatapos ng 1-year prescriptive ban sa impeachment na ating punong maestrado. Okay. Ngayon, pag convicted, of course, wala na po kaming gagawin kundi magtrabaho uli bilang isang mambabatas.
Okay. Thank you very much, Attorney Jimeno and Representative Tanyada, and see you later inside. Igan, Vicky, this is a very historic moment. Sabi ni Senator Soto, pagbukas ng Senate, diretso tayo sa botohan. Igan, Vicky.
Alright, maraming salamat sa iyo, Joseph Morong. At dumako naman po tayo sa The Medical City kung saan nakakonfine ang punong maestrado.
Mayroon pong ulat doon si Lia Manialac del Castillo. Lia.
Igan, Vicky, nananatili pa rin nga dito sa The Medical City si Chief Justice Renato Corona. Naroroon siya sa kanyang private room sa ika-15 palapag nitong ospital. At ayon sa mga impormasyon na ating nakalap, ay kasama ni Corona ang kanyang buong pamilya. Yung kanyang may bahay na si Mrs. Cristina Corona, yung kanyang anak na si Francis at si Carla, at maging yung kanyang mga apo ay naririto rin para nga bigyan suporta ang kanilang lolo. At sa huling pagkakataon na naka-text natin si Chief Justice Corona kahapon, ang isinagot lamang natin niya sa atin nang siya'y ating kamustahin ay God bless you. At itinanggi rin niya na mayroon siyang Twitter account. Yung kanya namang anak na si Francis, sinabi na pinapasa Diyos na lamang ng kanilang pamilya ang magiging kahihinatnan ng naging impeachment trial ng kanilang ama. So nakaantabay pa rin tayo dito sa The Medical City kung mayroon mang magiging reaksyon o pahayag ang pamilya Corona sa ibababang hatol ng mga senator judges. Igan, Vicky?
Alright, maraming salamat sa iyo, Lia Manialac del Castillo.
Alamin naman natin ang sitwasyon sa mga kilos protesta kaunay sa pagpapababa po ng hatol ngayon ng impeachment court.
At mula sa Pasay, may ulat si Mark Salazar. Mark, kamusta na dyan?
Arnold, Vicky, yung nasa kanan ko, no, sa tapat mismo ng Film Center ay yung grupong Akbayan at katatapos lamang magsalita ni Akbayan Party List Representative Walden Belliot, inisa-isa niya sa kanyang miyembro ang mga dahilan at katwiran niya kung bakit dapat guilty ang boto ng laban kay Chief Justice Renato Corona. Itong grupong Akbayan ay ikalawang grupo na nagkilos protesta dito sa labas ng Senado. Kanina bago mag-alas 12, narito ang grupong Health Alliance for Democracy na bumoto rin ng guilty, of course, mga boto sa labas ng impeachment court at dito sa kalye sa labas ng Senado. Hindi naman masyadong makapal yung grupo na ito. Actually, mas marami pa kung titingnan mo yung nakadeploy na police mula sa Pasay, mga riot police na may suporta mula sa National Capital Region Police. At ang iniiwasan kasi mangyari, Arnold, Vicky, ay yung magpang-abot yung dalawang opposing group dahil inaasahan namin maya-maya lamang na dumating din dito yung mga pro-corona naman sa pangunguna ng Employees Association ng Supreme Court. At ang iniiwasan nila ay yung magkapansabay sila at magkainisan at umabot sa hindi maganda ang eksena. Vicky, Arnold.
Okay, meron bang ibang grupo pa dyan na Mark, iiwasang makatabi ang grupong yan? Kasi ito proto, no?
Ito ay mga guilty to. Mga guilty ang kanilang hatol. Ang inaasahan nating darating, Arnold, maya-maya ay yung mga acquit naman, dahil yun yung mga Employees Association naman ng Supreme Court. Actually, yung dalawang grupo lang naman yun ang iniiwasang magdikit at magkaasaran at para hindi naman magkaroon ng gulo rito.
Alright. Mark, gaano katagal sila mananatili dyan? Kasi hindi natin alam, no, kung gaano katagal ito ang magiging kaganapan, ang magiging voting.
Oo, yung Health Alliance kanina for Democracy, hindi na sila nagtagal kasi nahabol rin nilang makauwi at makapanood sa TV ng proceeding, yung verdict na inaasahan natin na alas 2 ng hapon. Etong grupong ito, dito na raw nila tatapusin at dito sila makikibalita kung anong decision sa loob ng mga senator judges. Ngayon, pagkatapos ng desisyon, kung ano man, ay doon na rin nila tatapusin ang kanilang programa. Vicky.
Mark, gaano kalaki ang pagtitipon na yan? Pinakamalaki ba yung nakita mo kumpara sa mga nakalipas na araw?
Hindi. Medyo konti lang ito. Hindi ko naman kayo mabibigyan ng eksaktong estimate. Pero siguro, Vicky, ito yung mga nasa 500 lamang siguro. Ang nagpakapal dito, Vicky, pasensya ka na, hinawakan ko, tenga ko. Kasi maingay sa tabi ko, kaya hindi kita maririnig. Pero kung titingnan mo, nagpakapal dito, yung media nagko-cover sa kanila. Yung mga nakadeploy ng police.
Okay. Ano yung mas marami? Yung usually, yung nagpaprotesta, yung mga guilty ba o yung not guilty?
Sa ngayong araw na to, yung guilty. Ang mas marami kasi ikalawang grupo na nga ito. Yung mga empleyado naman ng Supreme Court, narinig natin sa mga report kanina mula sa mga kasamahan natin sa Supreme Court na wala namang court holiday. Kaya inaasahang hindi naman din sasama lahat ng empleyado para magpakita ng suporta sa kanilang punong maestrado. Eto medyo buhos na hanggang kaninang umaga yung mga may placards na guilty.
Malakas bang ulan?
Makulimlim. Ganito na to, kanina pang umaga. Maganda para sa amin, hindi masyadong masakit sa balat yung init, pero nagbabadyang uulan na hindi. Kanina umambon, pero hindi naman bumuhos ng malakas.
Alright, sige.
Maraming salamat, Mark Salazar po.
At balik po tayo ngayon sa Senado. Naroon din si Sherry Ann Torres. She, balitaan mo kami, sino-sino na yung mga nakikita mong personalidad dyan?
Yes, Vicky, bago yan, ikukwento lang natin yung nangyari ilang segundo pa lamang na nakararaan. Itong si Deputy Lead Prosecutor Rodolfo Fariñas ay lumapit dito kay Defense Lead Counsel Serafin Cuevas at sila ay masayang nagyakap, nag-usap sandali at sumunod doon sa kanya na lumapit naman itong si Lead Prosecutor Niel Tupas at nagkamay ng mahigpit at gaya ng kaninang nangyari sa kanila ni Fariñas ay masigla na nag-post dito sa harap ng mga cameramen at mga photographers. Maliban dyan, Vicky, hindi pa man nag-i-start, mga 1:30 pa lamang, puno na yung audience gallery dito sa loob ng session hall, magkabilang side, left and right, gayon din yung VIP section. Ilan dito sa mga prominente na nakita natin dito na maagang dumating ay itong si Armida Sigonreyna, nakababatang kapatid ni Senate President Juan Ponce Enrile. Andito andito rin etong sila Beth Ansioco, isang NGO, at pati na ang Black and White movement na kinabibilangan nga nitong sila Vicente Romano at nitong si Lea Navarro. Namataan din natin dito, Vicky Igan, itong si Vicky Bello, gayon din itong sila dating Senador Ernesto Maceda, itong si Attorney Vitaliano Aguirre na matatandaan natin ilang buwan na nakararaan ay nakatanggap ng admonition mula dito sa Senado dahil nga sa kanyang pagtatakip ng tenga habang sinesermo na ng mga senador. Andito rin ang itong sa Bayan Representative Risa Ontiveros at ang mga congressmen dito, Vicky Igan, ang particularly pumuno dito sa may gallery, mula dito sa VIP hanggang dito sa audience ay talagang puro mga kongresista yung prominente na nakaupo. Hindi lang natin malaman kung meron ditong mula naman sa kabilang panig, kung itong mga nakapula ay mula dito sa kampo ni Chief Justice Renato Corona o hindi. Maliban doon, Vicky, very prominent din, kung makikita natin sa video natin, ang mga taga-prosecution panel, lahat ito, pati yung mga staff nila, ay naka-Filipiniana attire, habang ito namang mga taga-defense panel, lahat naman ito naka-suit, naka-Amerikanang lahat. At sa ngayon nga, kung makikita niyo sa ating monitor, kanya-kanyang post itong prosecution, gayon din itong defense panels para sa mga media men na nandito. Lahat ito, mga magaganda yung mga bukas ng buka, mga ngiti, habang gayon din masasabi naman natin itong mga taga-defense panel. Vicky, Igan?
Ano yung atmosphere dyan kumpara sa mga nakalipas na araw? Ibang-iba ba? Nararamdaman mo ba?
Oo, Vicky, kung titignan natin, kung maririnig din natin sa background mas masigla ngayon yung atmosphere, less yung tension na masasabi dahil nga siguro tapos na yung lahat-lahat, presentation of evidence, oral argument na tapos na, at tanging ang hinihintay na lamang natin dito ay yung magiging verdict ng senator judges. Oo, pero bago
Eto
na
na. Ito na, Sherry Ann, mukhang malapit na magsimula. Itong impeachment trial.
Alas 2 na ng hapon.
Ay, nagpipictura na. Last day na kasi.
Oo, eto na. Tapos maliban dito, Vicky, dahil nga sa sobrang animated na nung iba, sobrang sigla ng atmosphere dito. Kanina tumayo dito si Sergeant at Arms Jose Balahadja. At muli ay nagbigay siya ng warning dito nga sa mga nasa audience na kung pwede, kung ano man daw yung maririnig nila na verdict o kabuuang desisyon ng Senate Impeachment Court ay matuto na gumalang. At ang warning nga niya, yung mga mag-heckle o magbibigay ng hindi magandang komento o ingay sa gitna nitong session na mangyayari ay palalabasin at hindi na talaga makakabalik dito sa loob ng session hall.
Alright, sige. Maraming salamat sa iyo, Sherry Ann Torres.
Bakibalita tayo sa Korte Suprema sa Maynila.
May report po si Steve Dailisan. Steve!
Yes, Vicky Igan, sa mga sandaling ito ay punong-puno na itong lobby naman ng Korte Suprema kung saan nakaset up na yung monitor na mapapanood nitong mga empleyado ng SC yung makaganapan dyan sa Senado. Kanina pa lamang, Vicky Igan, talaga namang excited na yung karamihan sa mga empleyado, magkahalong kabaraw yung kanilang nararamdaman. Yung mga nakausap natin kanina, ang sinasabi sa atin silently, ang usal nila ay acquittal. Yung iba naman, Vicky, dahil tuloy yung kanilang mga pagtatrabaho ngayong araw ay meron sila mga binitbit na mga portable na television sets at doon na nga lamang daw sila tututok sa loob mismo ng kanilang opisina para hindi rin maantala yung kanilang trabaho. Kasabay nung kanilang pag-aabang dito sa magiging hatol sa kaso ni Chief Justice Renato Corona ay tuloy-tuloy din yung isinasagong rosary vigil at hindi raw ito tatapusin hanggat hindi nila nadidinig yung pinal na hatol ng impeachment court. Vicky Igan.
Alright, sige. Maraming salamat sa iyo, Steve Dailisan.
Bago tayo dumako sa ating talakayan, balikan muna natin yung 3 article of impeachment laban po sa punong maestrado.
Una po riyan ang Article 2 o akusasyong culpable violation of the Constitution or betrayal of public trust dahil sa di kompletong pagdedeklara ng punong maestrado ng kanyang mga ari-arian at cash assets sa Statement of Assets, Liabilities and Net Worth o SALN.
Matatanda ang inakusahan ng prosekusyon ng punong maestrado na magkaroon ng di bababa sa 45 ari-arian batay sa listahang inilabas ng Administrator ng Land Registration Authority o LRA.
Pero ayon po sa depensa, napatunayan daw nilang 5 lang sa mga ito ang talagang pag-aari ng punong maestrado.
Daging mainit na usapin din ang cash assets ni Corona sa pagharap ni Ombudsman Conchita Carpio Morales bilang hostile witness ng depensa. Siniwalat niyang may $82 accounts umano sa 5 bangko si Chief Justice batay sa report na ibinigay sa kanya ng Anti-Money Laundering Council. Ang fresh defaults daw, hindi bababa sa $12 million.
Pero pinabulaanan nito ni Chief Justice Renato Corona sa kanyang pagsalang sa witness stand. Git ng punong maestrado, nasa $2.4 million lang daw ang kanyang dollar deposits. Hindi raw niya dineklara ito sa kanyang salin alinsunod sa confidentiality provision ng Foreign Currency Deposits Act.
Ang kanya naman peso deposits umaabot daw ng 80 million pesos. Pero ayon kay Corona, hindi rin ito kanya. At kaya niya hindi dineklara sa kanyang salin dahil commingled funds daw ito o pinagsama-samang pondo mula sa ipon umano ng kanyang mga anak, gayon din ng pondo ng Family Corporation ng Basag Guidoto Enterprises Incorporated. Hindi na sumailalim sa direct at cross-examination ang naging testimonya ni Chief Justice Renato Corona. Bukod po sa Article 2, dalawa pang Article of Impeachment ang formal na inihain sa Korte ng Prosekusyon, yung Article 3 o akusasyong betrayal of public trust and or culpable violation of the Constitution. Dahil sa umano'y kawalan ng integridad ng punong maestrado sa pabago-bagong desisyon ng Korte Suprema sa ilang kaso.
Tanging ang presidente ng Flight Attendants and Stewards Association of FASAP na si Roberto Anduiza ang humarap na testigo. Iginit niyang kakaiba raw ang naging papel ni Corona sa pagbaligtad nito. Sa naunang desisyon ng Korte Suprema, pabor sa pagpapabalik ng mahigit 1,000 flight attendant na sinibak ng Philippine Airlines.
Panghuli po yung Article 7 o ang akusasyong betrayal of public trust dahil sa pagbibigay ng Korte Suprema ng temporary restraining order pabor sa pag-alis ng bansa ni na dating Pangulong Gloria Arroyo at dating First Gentleman Mike Arroyo. Tumestigo para sa prosekusyon si Judge Secretary Laila de Lima kung saan tinukoy niya ang sinulat na dissenting opinion ni SC Associate Justice Maria Lourdes Sereno kung saan nakasad po ang umano'y impluensya ni Corona sa paglabas ng desisyon pabor sa pag-alis sa bansa ng mga Arroyo.
Humarap din ang naging attending physician ni Ginang Arroyo na si Dr. Juliet Gopez Cervantes para isumite ang inisyu niyang medical certification matapos i-discharge ang dating Pangulo. Sa parehong articles, walang ipirepresentang testigo at ebidensya ang depensa.
Bago po natin simulan ang talakayan, kinagagalak po natin makasama ngayong hapon si Dean Pacifico Agabin, ang dating dekano po ng UP College of Law.
Magandang hapon po ulit, Dean Agabin.
Magandang hapon naman.
Ayan, simulan na po natin ang talakayan. Kasama pa rin si Dean Agabin at Professor Rowena Daroy Morales. Sumentro ho kahapon yung oral arguments sa yung bang intent, no? O impeachable ba? Yung di pagdedeklara po ni Chief Justice Corona ng kanyang assets doon sa kanyang SALN. So, ito ba, naresolve na ho kayo ng mga senador yung kung, kasi parang ang dating daw, lesser, no? Lesser offense to, yung hindi niya pagdeklara, kumpara doon sa mga inisa-isa na parang impeachable offense, no? Bribery, treason, at kung ano-ano pa. Din.
Yun ay isang technical argument, Arnold, na kinukuha nila doon sa rules of statutory construction. Ini-invoke nila yung Latin maxim na ius dem generis, no? Ang gustong sabihin yon kung ang enumeration ay followed by a general clause, yung lahat ng na-encompass sa general clause dapat kapareho doon sa preceding enumeration. Kaya sa Constitution natin, ang enumeration ay treason, bribery, graft and corruption, other high crimes, and betrayal of public trust. Ngayon, yung general clause doon ay yung other high crimes Kaya yung other high crimes should be on the same category as treason, bribery, and graft and corruption. Ang problema, yung sumunod ay betrayal of public trust. Ayun na hindi nakasama sa enumeration yun Kaya ibang klase yun, ibang kategorya yun.
Professor, may I ask you also na based on yung mga oral arguments na narinig natin kahapon, no, sa palagay nyo, may mga nakapagpabago pa ng kanilang desisyon base pa dito sa mga naging oral argument?
Ang nakuha nating signal nung pagkatapos ng oral arguments kahapon, they were ready to give their decision. Wala lang tayong oras. And there were also reports na whether or not there were those oral arguments, base sa mga napresenta na at base, remember, ang decision ngayon is ayon sa ebidensya, Yung appreciation nila ng ebidensya, and the evidence is appreciated in accordance with their conscience. Dahil isa pa yun, it's going to be based on evidence and conscience. Hindi natin alam kung ano ibig sabihin ng conscience. So pwede, no, na na-desisyon na ng kanilang konsyensya kung ano ang hatol ngayong hapon. So we don't know. Evidence, strictly speaking, is supposed to be what you call objective. But conscience is subjective. So, ina-appreciate yung something subjective, something objective by something subjective. Maganda kung magtugma yung dalawa. Hindi na.
Kaya ba ganun ang tanong na lang ni SP Enrile doon sa terminong kulpa? O yung ano ang injury kung hindi man nagdeklara ng dolyares o magdeklara man ng dolyares yung kanilang kliyente?
That was a legal question.
Oo
kasi in law, may ibig sabihin ng
Paano
culpa.
daw siya gagabayan? Kasi kaya niya tinanong, guide us, di ba?
Correct. Napansin natin na yung tanong ni Senate President Enrile, after na, nung yung famous na palusot term, which of course is very subjective. Ang ibig sabihin kasi ng palusot, sa intindi ng marami, yung hindi naman yun yung dahilan. Kaya lang, nung nahuli, may dahilan. And that dahilan is based on legal reasoning. So, may tinatawag tayong palusot based on moral, meaning, ano na yun, yung mga practical, whatever, at may palusot based on the law. Magagaling ang mga, remember, ang mga abogado sa depensa.
Din, may nabago ba after nung kahapon ng mga arguments?
Wala naman siguro, Egan. Kaya lang, yung tanong ni presiding officer Enrile, medyo mayroong legal implications yun eh.
Bakit po?
Kasi yung definition ng culpable violation of the Constitution, dinefine mismo ng prosecution na it should be willful or intentional violation.
Oo.
Kaya
So ngayon kailangan nila i-rule kung sa palagay ba ng Senator Judge, intentional o unintentional?
Ayun ang definition na binigay ni Congressman Pariñas sa kanya. Yun ang answer ni Congressman Pariñas. Kung ganon, dapat i-consider nila kung intentional o hindi yung pag-omit ni Chief Justice sa SALN niya, yung mga dollar accounts.
Ang problema lang sa intention, hindi natin alam kung anong nasa loob ng isipan ng isang tao. Sana may nagtanong ng diretso at palagay naman natin alam ang magiging sagot. Sinadya mo ba? Pero at least, di ba, that question by Senate President Enrile was meant to fill in that gap. Ano ang benepisyo sa'yo kung yung hindi mo pagdeklara?
Oo. As opposed to kung dineklara mo. Kung hindi mo dineklara, ayan, nandito tayo, di ba?
Correct.
Oo. Mas maraming cargo, kumbaga, kung hindi mo ideklara. As opposed to kung ideklara mo, ano mawawala sa'yo?
Correct.
Although yung isang binigay na dahilan na nga nitong si Cuevas is safety concerns. So of course, it's up to the senator judges
Kidnapping,
to assess
extortion.
kung talagang valid ba itong naging dahilan na ito.
I was wondering, takot siya kaya ngayon ng yung mga same fears? He exposed us much today. Yung mga nasa salen naman nun, hindi naman alam ng buong Pilipinas yun. O ngayon, naririnig siya ng buong Pilipinas. Ba't niya sasabihin ngayon? So, hindi ko maintindihan kung saan galing yung takot na yun.
Din, ano ba maging desisyon na yan? Kunyari, hindi pabor kay Chief Justice. So, may vacuum tayo sa Supreme Court. Sino ang maglalagay ng acting? Kasi dapat magdesisyon ng Judicial and Bar Council dun sa shortlist na ibibigay ng Malacanang Palace, hindi ho ba? Ngayong wala pa tayo sa ganung proseso, magbobotohan ho ba yung mga maestrado? Sino ang uupong pansamantalang punong maestrado nila?
Mayroon na ata silang rule, Iga, na kung sino man ang most senior justice.
Most senior po?
Oo, yun ang uupo temporarily. Ang most senior sa kanila si Justice Antonio Carpio.
Naku, di ba parang na siya, umayaw siya na siya ang susunod na Chief Justice ba?
Acting lang.
Acting lang. Okay, acting lang.
Okay. So, kung nakikita nating senaryo, kung acquittal, syempre back to work. Kung conviction, ano mangyayari ngayon? Paano yung transition of power?
Well, yun na nga, magkakaroon ng acting until such time na may appointed na Chief Justice.
But effective immediately?
Yes, immediately executory ang tawag natin.
And then they're given 90 days, right? I think Malacanang is giving 90 days to
ang ibig sabihin ng immediately executory, syempre, subject to yung mga formalities, no? Yung formal decision ngayon, that will be put down in writing, isa-serve yan dun sa kinauukulan, lalo na sa Supreme Court, etc., etc. Hindi naman na this very second, nakabalot na lahat doon. Subject to reasonableness and due process na tinatawag.
So what will happen to the previous decisions? Would that have any impact on the previous decisions of the Supreme Court at the helm of Chief Justice Renato Corona?
Ayun, yung decision ay ikwan naman eh.
Nandun na
For
yung
instance,
record
Hacienda
na.
Luisita, pwede pa bang baguhin yan? Hindi.
With finality na yun. Record na ng Supreme Court yun, ano?
And not only that, I don't think there was any indication na si Chief Justice lang ang bumoto, one. And second, nung bumoto naman siya, nung kasama nung iba, Justice naman siya ng Korte Suprema. Hindi naman pwedeng retroactive, bali wala lahat ng ginawa niya. Hindi naman pwede yun.
Dinagabin, sinasabi kahapon ni Defense Counsel Dennis Manalo na un-impeach yung testimony po nitong si Chief Justice Corona dahil hindi siya na-subject sa cross-examination. So, ibig sabihin, wala man itong value, no, sa tanong na pinukul ni Deputy Lead Prosecutor Rodolfo Pariñas kaugnay sa claim si Corona sa kanya pong cash assets. Pero narinig na publiko, di ba? So, hindi naman ni-strike out ng court, di ba? So, anong saysay ng testimonya?
Ang saysay ng testimonya ay tama yung sinabi ni Atty. Manalo, Iga, na un-impeach. Kaya nga lang, ang problema ay inadmit ni Chief Justice na mayroon siyang $2.4 million at mayroon siyang 80 million pesos sa bangko. Kaya yun ay tinatawag na admission against interest. Kaya hindi na siguro nag-cross ang prosecution kasi alam nila na mayroong admission na pabor sa kanila eh. So, ayun ang sinasabi ko kahapon, it was incumbent upon the Chief Justice to prove why or to justify kung bakit hindi niya sinama sa SALN itong 2.4 million at yung 80 million.
Sorry din, nade-distract ako ni Atty. Aguirre.
Italiano Aguirre.
May nagpapapicture. Gusto yung famous na ano niya. Tinatakpan yung tenga niya. Buti na siya isa sa mga makulay na personal dito sa impeachment court. Pero anong reaksyon nyo din na kahit papano, nagkaroon tayo ng full-blown na impeachment trial, matatapos ngayon, meron tayong pagbabasyan kung may mga susunod pang may impeach na mga public official, no? Marami tayong natutunan dito.
Tama yon, Arnold. Kaya sa susunod na mga impeachment proceedings, parang president na sa atin ang mga rules na ginawa ng Senado at kung anong nangyari dito. Ang procedure na sinunod ng Senado, ito yung sa tingin ko, ito yung ideal na procedure na appropriate para sa mga criminal cases. Doon sa Amerika, noong na-impeach si Clinton, hindi nila sinunod itong mga ganitong technical rules of procedure. Yung isang van na puno ng dokumento ng special prosecutor, hindi na nila binasa yung mga dokumento. Decide na lang sila on the legal issue as to whether Clinton's falsification under the circumstances would be impeachable.
All right.
Professor, may aral ba tayo pare-pareho dito?
Oo, kung ano dapat gawin at hindi gawin ng prosecution at ng defense. Lalo na ng prosecution.
So yung public accountability dito, buhay na buhay at dapat matuwa ang tao dito.
Oo, palagay ko itong nangyayari sa atin ngayon, culminating today, is a very good illustration of democracy at work. Hindi totoo yung sinasabi nilang this is a sign of a constitutional crisis. It is a sign of constitution at work. Hindi po ba?
Oh.
That's right.
Tsaka everywhere you go, parang lahat ng tao talagang involved dito sa process na ito. No? It's like as if everyone has a stake in it. You ask everyone, they have their own opinions as far as acquittal or conviction is concerned. And it's good. And I'm sure, kahit yung mga senador siguro, medyo matinding bonding sila the past couple of weeks, months. So I guess they've gotten closer, more solid as a team.
Hindi lang yun. Palagay ko, yung mga senator judges, and kumbaga their ears are on the ground, finding out kung ano din ang sinasabi ng mga tao.
Speaking of ears on the ground, you think the coming elections has a lot to do with how the voting will go?
Yes, I think pag yung ears on the ground, at the bottom of that ground is yung election.
May mga estudyante ba kayo sa private prosecution tsaka sa defense?
Yes, both.
Kunyari sa defense, negative yung resulta, paano yung career nito? At least nagkaroon sila exposure, no?
Well, talagang
maganda naman yung naging laban din nila, no?
Yeah.
Depende siguro sa performance nila, di ba, Igan? And I think all of them performed well.
Naging fair ba ang impeachment court? Naging pataso ba sa tingin nyo din?
More than fair.
More than fair.
Kasi sabi ko nga, si Senate President was very liberal in extending the usual courtesies and acceding to the requests of both parties.
Okay.
All right.
Ito na yung mga hukom.
One more time with feeling. Nagsisimula na po ang impeachment proceedings. Panoorin po natin ito.
Okay. The continuation of the impeachment trial of the Honorable Chief Justice of the Supreme Court, Renato C. Corona, is hereby called to order. We shall be led in prayer by Senator Manuel Manny Villar.
Almighty Father, in Psalm 58 you asked, "Do you rulers indeed speak justly? Do you judge uprightly among men?" Maraming salamat, Panginoon, sa inyong mga salita. Higit namin kailangan ito ngayon, habang ginagampanan ang aming mga tungkulin bilang hukom sa paglilitis na ito. Salamat, Panginoon, sa makasaysayang araw na itidakdan ninyo upang tuldukan ang paglilitis na ito. Ito ang katapusan, ngunit ito rin ang simula. Simula ng panibagong gawain para sa inyong mga lingkod. Ano man ang hatol, tulungan ninyo makausad ang aming bansa na dala-dala ang bagong pag-asa na inyong ipinangako. Tulungan po ninyo kami sa aming tunay na gawain na matulungan ang mga walang trabaho, ang mga nagugutom, ang mga maralita, at ang mga nangangarap. Basbasan mo po kami na sa pag-unlad ng aming demokrasya ay ang pag-usad rin ng aming ekonomiya. Mahaginan mo po kami ng iyong karunungan at pangunawa. Ikaw ang magsilbing gabay at ilaw sa pagbuo ng aming desisyon. Mangibabaw nawa ang respeto sa bawat isa. Mangibabaw nawa ang paggalang. Mangibabaw nawa ang katarungan. At higit sa lahat, mangibabaw nawa ang tama. Pinapanalangin namin, O Diyos, na manaig ang mga testigong nagsasabi ng totoo, manaig ang mga testimonyang walang bahid ng kasinungalingan, at higit sa lahat, manaig ang katotohanan sa lahat ng ito. Give unto us the strength of discernment to choose what is right and honorable, as guided by our conscience and steered by your divine will. As you said, finally, consummatum est. To God be the glory. Amen.
Amen. The Secretary will now please call the roll.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Direlon, Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Ligarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revilla, Soto, Trillanes, Villar, the Senate President.
With 23 senator judges present, the presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant-at-Arms to make the proclamation?
The Sergeant-at-Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the May 28, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the May 28, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. The Secretary will please call the case before the Senate acting and sitting as an impeachment court.
Case number 002-2011 in the matter of impeachment trial of Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, may we ask the parties and or their respective counsel to enter their appearances?
Good afternoon, Mr. Senate President and ladies and gentlemen of the Senate. On the part of the House of Representatives Prosecution Panel, same appearance, we are ready, Your Honor.
Noted. The defense.
For the defense, Your Honor, the same appearance. We are ready for the scheduled promulgation of the decision in this case, Your Honor.
The Majority Floor Leader.
Mr. President, the Senate has met as an impeachment court for 44 trial days, starting January 16, 2012, to consider the articles of impeachment against Chief Justice Renato C. Corona. The court convenes today to conclude this trial by voting on the articles of impeachment. Mr. President, pursuant to Article 11, Section 3, Paragraphs 6 and 7 of the Constitution, and Rule 21 of the Rules of Procedure on Impeachment Trials, we are ready to vote on the articles.
Before we proceed, the Chair would like to remind the members of the Court, the parties to this case, and the public that on March 12, 2012, this Court ruled that no evidence from both the prosecution and the defense will be received and no verdict will be rendered on Articles 1, Roman numeral 1, Roman numeral 4, Roman numeral 5, Roman numeral 6, and Roman numeral 8. In accordance with that earlier ruling, the votes will only be taken on Articles Roman numeral 2, Roman numeral 3, and Roman numeral 7. The Clerk of Court will now read Article 2.
Article 2. Respondent committed culpable violation of the Constitution and / or betrayed the public trust when he failed to disclose to the public his statement of assets, liabilities, and net worth as required under Section 17, Article 11 of the 1987 Constitution.
The question is on the second article of impeachment. Senators, judges in this impeachment court, is the respondent Renato C. Corona, Chief Justice of the Supreme Court, guilty or not guilty? The clerk of court will now call the roll, and each senator shall have time. We will not limit the time. This is a historical event, and each one of us must vote according to his conscience and explain the reason for his vote. So therefore, each senator shall have as much time to explain his or her vote in this case. Proceed.
The Honorable Senator Judge Angara.
Thank you very much, Mr. President. Mr. President, esteemed colleagues, distinguished brothers in the profession from the prosecution and defense, ladies and gentlemen. Kung nalaman ko lang, dinala ko na yung libro ko, Mr. President. Sa nakalipas na 5 buwan, ang atensyon ng sambayanan ay nakatuon sa impeachment trial ni Chief Justice Corona. Mula sa pagiging pribadong abogado, siya ay nanungkulan sa ilalim ng 2 pangulo at nahirang bilang pinakamataas na mahistrado, isang natatanging tagumpay para sa isang abogado at ang pinakamataas na posisyon sa isa sa 3 magkakapantay na sangay ng pamahalaan. Ngunit napapaloob po dito sa isa pang istorya. Ang kwento ng isang pamilya na pinagwatak-watak ng mapait na away tungkol sa pag-aari at pera. Tumagal ng 30 taon ang away, nauwi sa dimandahan at humantun pa dito sa paglilitis natin. Pera, kapangyarihan, away, pamilya, ito po ang ugat ng istoryang ito. Hindi ang lahat ng ito ay matutugunan natin sa paglilitis na ito. Subalit, hangad ko po, na sana dito rin ay magkaroon ng hantunan o closure ang away pamilya. The question, Mr. President, is quite simply, is the Chief Justice alleged failure to disclose a true and complete statement of assets as mandated by the Constitution, and whether this constitutes culpable violation of the Constitution and or betrayal of public trust. The Constitution and our statutes oblige every public official to make and submit, and I quote, a complete disclosure of his assets, liabilities, and net worth, or SAL-N, in order to suppress any questionable accumulation of wealth. This obligatory constitutional rule seeks to eradicate corruption, promote transparency in government, and maintain a standard of honesty in public service. The prosecution and the defense, Mr. President, combined as one in producing proof that the Chief Justice has bank accounts that he did not declare in his SALN, and removing any iota of doubt about this vital fact was the Chief Justice himself coming here to testify openly and openly admit that in fact he did have $4 accounts totaling 2,400,000 and 3 peso accounts of 80,700,000 pesos. I may grant the Chief Justice plea of honest mistake of judgment, but given his broad experience in public law and practice in investment advisory services, this willful and deliberate omission, together with the magnitude of the amounts involved, amounts to culpable violation. Yesterday you were asking what's the root meaning of culpable, Mr. President. I just looked up this morning what is the dictionary meaning of culpable. It means simply a failure meriting condemnation. The Chief Justice justified his willful failure to disclose his US dollar accounts on the so-called absolute confidentiality provision of the Foreign Currency Deposit Act. However, it seems clear to me, Mr. President, that the mantle of protection is extended to foreign depositors, to foreign savers, in the spirit of promoting foreign investments. The law was never intended to be a convenient excuse for Filipino, especially for Filipino public servants, to conceal their assets. When the accounts were disclosed by no less than the Chief Justice, this left this court no restraint, no constraint, no prohibition against admitting the evidence and weighing it on the scale of justice. The defense argues that the Ombudsman illegally obtained documents on Chief Justice bank transactions where there was no pending case involving the subject bank accounts, or any court order authorizing the production of such records. Mr. President, this argument overlooks one important fact. It fails to consider that the documents produced by the AMLAC, or rather produced by the Ombudsman, were official records of the AMLAC, which it receives from covered institutions pursuant to law. The Ombudsman has the power and the authority to obtain these records from the AMLAC pursuant to the Constitution and the Chief Justice's own written waiver on his SALN. On the whole, Mr. President, the defense main objection doesn't sound acceptable. It rings hollow to me, since the Chief Justice himself admitted to the existence of the accounts, and more than that, the amounts they held, not to mention the fact that information on these were provided by witnesses presented by the defense panel themselves. The Supreme Court no less has said, no position exacts a greater demand on moral righteousness and uprightness of an individual than a seat in the judiciary. As the head of the judiciary, a standard far higher is placed on Chief Justice Renato Corona. This impeachment breaks new ground. This Senate, sitting as judges, adopts its own rules and makes its own decision within the bounds of the rule of law. It can initiate new doctrines. It can pass new precedents. Its pronouncement is the final word. It seems unnecessary for me to dwell further, Mr. President, on the 80.7 million account of the Chief Justice, which he said is a commingled fund, commingled with the funds of his children and the Basa Guidote family. But this fund could very well provide the seed of reconciliation for the two feuding branches of the family. For this reason, Mr. President, I find the respondent guilty.
Secretary.
Honorable Senator Judge Arroyo.
I will not discuss what both the prosecution and the defense had already argued in the closing arguments. Mr. President, esteemed colleagues, impeachment is a political process, not a political assassination. An impeachment aspires to be a judicial proceeding that makes it imperative that it stick to judicial rules. And impeachments must ever uphold the due process that no citizen, high or low, can be denied. That is why we wear judicial robes, as you see them, to listen, to ponder, and decide like judges according to law. What started in the House was not an impeachment. For an impeachment is an accusation accompanied by necessary formalities, attended by the appropriate solemnities, flanked by the liberties and guarantees that a genuine grand jury proceeding affords. The purpose is to arrive at a sound finding of probable cause, sufficient to lodge a valid complaint, charging real offenses before the appropriate tribunal. The Senate is being asked to remove the Chief Justice from office, all because he submitted an allegedly erroneous SALN. The Senate trial could be as close to a criminal proceeding in a court of law as non-lawyers can approximate. Thus far are all the great authorities agreed. What has happened is the passage that to which the Senate President once warned that we were veering close to a bill of attainder. A bill of attainder is a law passed by one house and approved by the other, creating an offense where there was none, inventing a crime out of actions, willful or not, that were innocent when they were performed. It is a legislative act of convicting an accused of acts that were not offenses in the very measure by which he is condemned, through a vote instead of a trial, on the basis of accusations taken as proof. I cannot imagine removing a Chief Justice on account of a SALN. Today, we are one step from violating the Constitution and passing a bill of attainder. No one can stop us if we do not stop ourselves. This is not justice, political or legal. This is certainly not law. For sure, it is not the law of the Constitution. It is only naked power, as it was in 1972. I had not thought that I would see it again, so brazenly performed. But for what it is worth, I cast my vote, if not for innocents falsely accused of offenses yet to exist, and if not for the law and the Constitution that we were privileged to restore under Cory Aquino, then because it is dangerous not to do what is right. When soon we shall stand before the Lord, I vote to acquit. Thank you.
Honorable Senator Judge Cayetano Alan Peter Compañero.
You shall do no injustice in judging a case. You shall not be partial to the poor or show preference for the mighty. But in the righteousness and according to the merits of the case, judge your neighbor. Leviticus 19:15. Why do we complicate the simple? Di ba simple lang naman ang issue eh. Sino ba nagsasabi ng katotohanan? Ano ba ang katotohanan? Base sa ebidensyang naibigay dito sa korting ito, ano ba ang katotohanan? Almost 10 years ago, nasa Amerika po kami at nagpapagamot po ang aking ama. Hindi pa namin alam at that time na may cancer na pala po siya sa tiyan. Dahil gabi-gabi naman siyang umiiyak, sa sakit po, around 2 o'clock in the morning, tinanong ko siya, Dad, anong masakit? Nagulat po ako sa sagot niya dahil sabi niya, Alan, 40 years ago I studied here, I worked here, but I was determined to go back home. 40 years later, nandito na naman ako, ang dami ng ibang umunlad na bansa, ganun pa din tayo. Nabasa ko sa kanyang mata ang simpleng katotohanan na yung corruption at kahirapan ay dinudurog ang spirito ng isang nadudurog na ang katawan. Mas masakit pala yon na yung spirito at pag-asa ang nadudurog, lalo para sa sariling bayan. Gusto ko po magbago ang ating bansa. Gusto ko po na makita na nakatawa din ang aking ama. Ngunit meron din pong cancer ang ating lipunan. Cancer na ang ibang batas at ang ibang pamantayan o standard sa ating lipunan ay iba para sa mayaman at mapangyarihan at iba para sa mahirap. Cancer ng korupsyon. Cancer na para sa mga mayaman at makapangyarihan ang simple ginagawang komplikado. Dahil sa cancer na ito, iba't iba ang interpretasyon ng batas sa mayaman at mahirap. Hindi ko po matanggap ang interpretasyon ng pinakamataas na hukom ng ating bansa na yung $2.4 million ay hindi kailangan ideklara sa SALN sa ilalim ng 6426. Hindi ko po pwedeng matanggap na isang public official sa isang simpleng ploy o paraan na i-convert niya ang kanyang pera sa dolyar ay pwede na niyang hindi ideklara sa SALN. Kaya po ba natin tanggapin ang interpretasyon na kung ang $2.4 po ninyo ay ilalagay nyo sa safety deposit box, ilalagay nyo sa kaha de hierro doon sa inyong opisina, or itatago nyo sa baul sa bahay, ay kailangan itong ideklara sa SALN? Pero pag dineposit mo sa $1 account, hindi mo na kailangan i-deposit sa SALN? Mukhang ginawa nating komplikado ang simpleng-simple. Pesos, kahit may confidentiality, kailangan ideklara. Pero pagdating po sa dollars, hindi kailangan ideklara. Pati ba naman sa pera, may diskriminasyon tayo? Pati ba naman sa sarili nating bansa, mangingibabaw pa ang dollar sa peso? When a public official, especially a judge, is faced with two possible interpretations of the law, one which will give life to the spirit of the sovereign will of the people embodied in the Constitution, and another that will protect only himself. It is his moral, human, constitutional duty to choose to protect the Constitution and not himself. If a public official has a choice between harmonizing several laws with the Constitution, 6713, 6426, and the other choice is to make them repugnant with each other o hindi pwedeng magpagsama, ano dapat niyang desisyon? Hindi ba simple? Lahat ng abogado alam yon. You construe it that you will harmonize all of these laws. Ito po ang tanong ko. Paano po kapag ka may kaso ang 1.3 million civil servants, ilan man sa kanila, isa, dalawa o marami, sa Korte Suprema? Paano kung halatang-halatang tinago lang ang pera pero dollar account ang ginamit? Will the Chief Justice have the moral ascendancy now to convict that public official? Hindi pwede. Dahil sa sarili niyang depensa, ginamit niya na yung interpretasyon na to. Sana po, kaya kong tanggapin na yun ang interpretasyon niya, but just in case, dineklara pa rin niya. I would respect him for that. This is what I think the law is, but this is what's good for the country. Therefore, idideklara ko pa rin. Hindi ko rin po matanggap ang interpretasyon ng 80 million na aminado niyang hindi dineklara or part of it ay hindi dineklara, ay ipapaliwanag niya sa pamamagitan lang ng isang kwento na wala siyang isasubmit sa atin na ebidensya. walang ITR ng mga anak niya, walang mga resibo, walang mga passbook. Sasabihin lang po na based on his credibility. I'm not saying he's not credible. But if it was anyone else, if it wasn't CJ Corona in the stand, tatanggapin ba natin yung sagot na yon? O sasabihin natin, ano ba ang iyong ebidensya? Especially when the explanation is against human experience or normal human experience. Marami po na mga may edad na sa lipunan, nilalagay sa anak ang mga account nila. Pero tama po, bihira yung anak ang nilalagay sa kanilang magulang. Bakit ang isang clerk hindi lamang nagdeklara ng isang stall sa palengke, tinanggal na? Bakit ang mahirap pag nagnakaw, bawal? Ano ba sinasabi natin sa mahirap? Bawal magnakaw. Bakit sa mayaman, bawal magnakaw? Ng konti. Kasi pag nagnakaw ng marami, lahat na ng technicalities, lahat na ng batas, lahat na ng pwedeng ikomplika ang sistema para protektahan siya ay nasa kanya. Bakit po pag mahirap na huli ang sasabihin sa kanya, sa presinto ka na magpaliwanag? Bakit po pag mayaman, lahat ng lusot, batas, technicalities available sa kanya? Sa totoo lang po, sobra po ang ganda ng pagpapatakbo ng ating presiding officer ng korte na to. And I admire the prosecution and the defense, and I admire my colleagues. Pero let's be honest with each other, 44 days, more than 200 hours. Sa totoo lang po, isang linggo, kaya natin tapusin to. Kung nilagay na lang natin sa stand at nagsabihan na lang tayo ng totoo sa isa't isa. At tingin ko po, kung mahirap po ang akusado, nasa presinto, nagpapaliwanag na lang siya. Tignan niyo po, kahit sa cellphone. Di ba pag mahirap, nahulihan ng asawa na may sweet na text sa iba? Ano sabihin niya? Honey, missent po yan. Hindi ko sell yan. Pag mayaman, kukuha ka pa ng abogado? Sasabihin mo pa? Darling, hindi ko text yan. Hiniram ng iba yan. Nakikigamit lang ako ng cellphone o share kami in trust yan. Commingled ang mga text kaya hindi akin yan. Why do we complicate what is so simple? Technicalities which should protect the rights of people. And I don't blame this court for sticking to technicalities because this is supposed to protect the rights of people. Pero somehow in this country, it is being used to protect people who plunder this country. I remember my law professors at Ateneo School of Law. Sabi niya sa amin, and those of here who graduated from the same school would remember this. If you are strong on the facts, pound on the facts. If you are strong on the law, pound on the law. But if you are not strong or you are weak both on the facts and on the law, pound on the table. Pukpukin ang batas kung doon ka malakas. Pukpukin ang katotohanan o ang facts pag yun. Pero pag hindi, pukpukin mo na lang ang mesa. Yun po ang turo sa ating mga abogado. But can't we agree as a nation to pound on the truth, to pound on justice, and to pound on grafters in this country? Sabi po nung iba, mabait daw po si CJ Corona. Sabi nung iba, hindi siya notorious sa Supreme Court. Actually, kilala din po namin siya at mabigat po sa amin. Some describe him as decent. Kaya sabi po ng iba sa akin, mag-abstain ka na lang kasi komplikado naman ang batas, komplikado naman ito. This is my reply to them with all due respect. If your client cannot explain, I cannot abstain. If you did not disclose, we have to depose. And if you are not fit, you cannot sit as the CJ of our Supreme Court. You will have your day in court. You will have your day in media for civil case, for a criminal case. But for the impeachment case, ang pinag-uusapan po natin yung kabutihan ng ating bansa. The impeachment court does not simply pass judgment on this specific case or on this specific CJ. The court's action being far-reaching and precedent-setting is actually rebuilding a new paradigm of transparency and accountability in public office. The verdict of this court will affect 1.3 million or more than 1.3 million civil or public servants, government employees and officials. It will affect 100 million Filipinos here and abroad. It will affect our future because transparency and accountability fights corruption. and corruption has a direct correlation to investments, business, jobs, prices, and the quality of services we give our people. Ang korupsyon po, direkta ang epekto sa presyo, sa kawalan ng trabaho at sa kita ng bawat mamayan. I cannot agree with the CJ's interpretation of the law in his explanation that the 80 million pesos and $2.4 million. However, in signing the waiver that allowed the Ombudsman to look into bank accounts, he has set a new standard. Bagong pamantayan. Sabihin nyo man napilitan na siya, sabihin mo na lumabas, pumirma pa rin siya at sinubmit niya yung waiver. We should all follow this standard. Etong pamantayan na to ay dapat para sa atin lahat. Transparency of bank accounts is good. I asked the President to instruct his cabinet, sign the waivers or resign and leave government. Executive, Legislative, Judiciary, COA, COMELEC, BIR, Customs, Judges, Governors, Mayors, Barangay Captains, Congressmen, Senators, let us agree on one standard. At least, ito pong ginawa ni CJ ay maganda. We can agree on safeguards and protection. Hindi naman ibig sabihin na lahat na lang ikakalkalin ang bank accounts, di ba? Payagan natin ang ombudsman na kung may kaso o issue laban sa inyo, makita niya at tignan po ito. Hindi po pang-haras o pang-abuse to. But all of us should have the same standard. The waiver taken together with the SALN at kung maipapasa natin ang Freedom of Information Law, we will have entered a dawn of transparency and accountability in our country. It will be a new milestone in the tuwid na daan. For myself, gagawin ko po ito. Pag ako inimbestigahan ng ombudsman, papayag po ako na buksan ang aking account. Okay po ako sa waiver. Wala dapat ikatatakot kung walang tinatago. Ayoko rin iharas, ayoko rin kulitin. Pero wala po tayong choice. Kung gusto natin magbagong bansa, dapat pare-pareho. Hindi ko makakalimutan ang pag-iyak ng aking ama nung gabing yon, hindi dahil sa sakit ng tiyan o dahil ang katawan niya unti-unti pong nadudurog na sa sakit, kung hindi dahil sa pagmamahal ng kanyang inang bayan, ang bansang Pilipinas. Nais ko po ng pagbabago. Nawa sa desisyon na ito, nakapag-ambag, nakatulong po ako ng konti. Masakit man ang proseso, sana nagdulot ito ng pagbabago sa ating bansa. Presume him guilty, presume him innocent, give him his day in court, ascribe to him good faith, yes, sa civil and criminal cases, sa media, etc. But not today and not in this impeachment court. Guilty with the penalty of removal from office.
Honorable Senator Judge Cayetano Pia.
Today, we face a difficult task of deciding whether the man who holds the highest position in the Supreme Court has committed acts tantamount to betrayal of public trust that would warrant the removal from office. It is all the more difficult for me because I took my oath before this man. If this were a purely legal process, my legal training would require that much of the evidence presented is disregarded due to irregularities in obtaining the same. But this is not a purely legal process. The framers of the Constitution did not set the quantum of evidence nor the burden of proof required to convict. Much was left to the individual conscience and the collective wisdom of the Senate. Further, impeachment cases are heard by senator judges with different professional backgrounds. Of the 23 senator judges, less than half of us are lawyers. Thus, I was challenged and admittedly burdened by the need to balance my legal training as a lawyer and my calling as a public servant, particularly a senator judge. The Chief Justice states that the requirement in the Constitution to declare one's assets, liabilities, and net worth is as may be required by law. He then cites Republic Act 6426, or the Foreign Currency Deposit Act, as that law, which states that dollar deposits are absolutely confidential, thus providing him with a shield. Is that the law in point? Is that the law that the Constitution stated will be required by law? I submit it is not. It is Republic Act 6713, the Code of Conduct and Ethical Standards for Public Officials and Employees, which, among others, requires the submission of a statement of assets and liabilities and provides the details thereof. It requires stating all kinds of assets, including cash on hand and in banks. There are no exceptions. To allow the contrary view would be setting a deadly precedent. It would allow any official to hide his assets behind the cloak of the Foreign Currency Deposit Act. Does that make sense? It does not, both from a legal point of view and from a lay person's view. Bakit pwedeng itago ang pera sa dolyar? Makatarungan ba yun? Republic Act 6426 on the secrecy of foreign currency deposit is not an exception to the law requiring the declaration of the SALN. In fact, it is easy to reconcile the same. A government official should declare his assets and liabilities, but then no one can examine the bank account without his written consent. The defense then posits the view that misdeclaration in the SALN is minor and therefore not an impeachable offense compared to other impeachable offenses like bribery and treason. As a lawyer, to me, minor inaccuracies in the SALN, such as parking lots or a unit whose ownership is under contention, would not amount to betrayal of public trust. In fact, corrections are allowed under the law. But the failure to declare $2.4 million and some 80 million pesos is not minor. In decided cases, the Supreme Court has ordered the dismissal from service of public officials and employees for failure to declare a sari-sari store, 2 motor vehicles, and for non-declaration of several assets such as real property and bank deposits. These are the cases of Rabe versus Delsa Flores, Ombudsman versus Nieto, Racho Flores versus Montemayor. I also have difficulty accepting the defense of commingled funds. Yes, the fact of commingling of funds, I believe, is common among families. But the huge amounts involved leads much doubt in my mind. In our interpretation of the law, we who hold a position of public trust must choose the interpretation that will uphold public interest over private interest, regardless of whether malice or an intent to suppress the truth was present. We must remember that public office is a public trust. Once that trust is gone, we must step down to preserve the integrity of the position we hold. Pag nawala po ang tiwala ng taong bayan, dapat po bumaba na sa pwesto. Dapat po pangalagaan ang posisyon na yon. Lastly, we need to remember that we can only mature as a democracy if we can learn from this impeachment experience. From the start, I questioned breaches in procedural law and ethical conduct of various participants in the impeachment process. The trial by publicity, the irresponsible hurdling of bloated, unverified figures and assets, among others. My fervent hope is in the future, the pursuit of justice will be conducted in a more responsible manner, lest our children are left with the impression that those accused of wrongdoing can be persecuted without respecting their rights. The other lesson must go beyond the Chief Justice. It is the call for transparency. I echo that call. Those of us who sit as judges, those of us who act as prosecutors, and all those in public service should not hide behind our titles. We must come clean and give meaning to the constitutional requirement that we declare all our assets. Mr. President, on the accusation made in Article 2, I find the respondent guilty.
Honorable Senator Judge Defensor Santiago.
The Constitution provides that in all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved. The burden of proof is on the prosecution. How much proof is necessary? In other words, what is the standard of proof? I have adopted the very high standard of overwhelming preponderance of evidence pursuant to the recommendation of Professor Charles Black of Yale University, author of The Impeachment, considered the Bible for the whole world on impeachment process in a democracy. My standard is very high because removal by conviction on impeachment is a stunning penalty, the ruin of a life. The defendant admitted that he did not declare his dollar accounts and certain commingled peso accounts in his SAL-N. Let us begin with this threshold question. Did this omission amount to an impeachable offense? No. Under the rule of justem generis, when a general word occurs after a number of specific words, the meaning of the general word shall be limited to the kind or class of thing within which the specific words fall. The Constitution provides that the impeachable offenses are culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. An omission in good faith in the SAL-N carries a light penalty and is even allowed by law to be corrected by the person who submitted it. Thus, it is not impeachable because it is not in the same class as the offenses enumerated in the Constitution. If we disregard this rule of justem generis, then we can interpret the law to mean anything as long as the enumeration of specific words is followed by a general word. Wala nang limitasyon yon. Pag sinabi pala ng Constitution, other high crimes or betrayal of public trust, wala na palang limitasyon yon. Yan, kung hindi ka nag-aaral ng batas. Sabi ng batas, you apply the rule of justem generis. Kailangan may listahan na isa-isa nilang sinasabi kung anong kasalanan at merong isang salita na hindi mo malaman kung anong kasalanan, dapat basahin mo yan na pare-pareho doon sa kasalanan na nalista na. In other words, it should belong to the same class. Does omission in the SAL-N belong to the same class as, for example, treason, bribery, etc.? The Constitution simply provides that a public officer shall submit a declaration under oath of his assets, liabilities, and net worth. I am quoting the Constitution. That is all. There are no details. The Constitution is a brief declaration of fundamental principles. Many constitutional provisions are only commands to the Congress to enact laws to carry out the purpose of the Charter. As a general rule, constitutional provisions are not self-executory. Hindi naman pwede na basahin mong Constitution na para ka bang nagbasa ng dyaryo, tapos kanya-kanya kayong interpretasyon. Hindi ganon yun. Kaya nga meron tayong constitutional law, which is said to be the most difficult subject to pass in the entire College of Law. Hindi ganon kadali magbasa ng Constitution. Constitutional analysis is a field of art in itself. It is a technical field. Kaya 4 na taon ang abogasiya. Kung basta sino lang pala pwedeng mag-interpret ng Constitution, bakit pa tayo may mga abogado? Kanya-kanya na lang. The usual exceptions are the Bill of Rights. Yan, self-executory yan. Basahin mo, sundin mo. And constitutional provisions. Pag sinabi ng batas, hindi pwede ito, yan, sundin mo kaagad. Pero lahat, hindi mo pwedeng masunod kaagad-agad. Mag-antay ka kung anong batas ang ipapasa ng Kongreso. Wala kaming ginagawa sa Kongreso kung hindi mag-antay kung anong sinabi ng Constitution. That is the main function of legislation. All other constitutional provisions, such as the Psalm provision, need implementing laws to provide the details. Hence, Congress, to implement this constitutional provision, has passed a number of laws, including the Foreign Currency Act, which confers absolute confidentiality on dollar deposits. Nakikinigla ako noon, sa mga argumento na the Foreign Currency Act violates the Constitution. I was already hoping with all my heart that God would strike me dead. Mabuti pang mamatay ako bilang isang abogada nang sa makikinig ako ng mga rason na ganon. Wala yan sa libro, wala yan dito, wala yan doon. Para bang hindi ka nagbasa ng batas mo. Di ibig mo sabihin, wala na palang batas na nag-iiral sa mga trial na ito. Kundi kanya-kanya ng isipan. There is no conflict between the Constitution and the Foreign Currency Act. The perceived conflict is so simplistic that it is seriously laughable. Nakakatawa ka o nagpapatawa ka. If there is any conflict, it is between the Code of Conduct and Ethical Standards on the one hand, which provides for a waiver of confidentiality, and the Foreign Currency Act on the other hand, which provides for absolute confidentiality. Kaya sinusunod natin ang batas sa konstitusyon, pero ang batas na pinairal ng Kongreso mukhang may conflict. Pero hindi mo masabi na the Constitution is clear, so the Constitution will of course prevail over an ordinary law. Ano namang klaseng kagaguhan yan? Galit kayo dahil ginamit ko ang salita na kagaguhan? I repeat, kagaguhan yan. Why do you study law if that is your opinion? At bakit matawagin na quasi-judicial itong proceedings na ito? If it's all purely political and anyone can have his own opinion. It is for Congress to balance, on the one hand, the need for public accountability from public officers with, on the other hand, the desperate need for foreign investment, which entails confidentiality on pain of driving away investors from our country. Yan ang rason kung bakit meron tayong Foreign Currency Deposit Act. Dahil gusto natin na paratingin ang foreign investment at walang foreign investor. I promise you na darating kung merong bayan na may batas pala na lahat ng dolyar mo, ideklara mo. Walang darating maski isa. That is the purpose of that law. Did anybody of you bother to find out why we have a Currency Deposit Act? Puro lang tingin ninyo tungkol sa impeachment. Iparking mong pera mo dyan. Mamaya, isasalungat ko yung mga argumento ninyong yan. It makes me angry, as a former law professor and as a future judge of the International Criminal Court, that you should presume to administer justice in this manner. I am insulted by the way your minds run. It is for Congress. The argument that a dollar deposit protected from inquiry would nullify the principle of transparency is for Congress to resolve. Ay di tayo, kayo sa House at kami sa Senate, tayo ang gumawa niyan, tayo ngayon ang may problema. Di bigyan natin ng solusyon ang problema. We could retain the absolute confidentiality clause with the amendment that Filipino public officers are not protected. Yon ang dapat gagawin natin. The prosecution mistakes admission for confession. In law, in a confession, the defendant admits his guilt. In an admission, the defendant merely states facts which might tend to prove his guilt. In the instant case, the defendant did not make a confession, but merely an admission with a legal defense. As a former RTC judge, I find it reprehensible beyond belief, that the AMLA document was introduced in evidence without authentication as required by the rules of evidence. Nagpapanggap-panggapan pa tayo na korte tayong quasi-judicial. Yun pala, sinabi pa natin na if there is any need, we shall use as a supplementary authority the rules of court. Yun pala, hindi natin susundin ang rules of evidence. Hindi ka pwedeng magdala maski anong papel sa korte. I-authenticate mo. Kung hindi mo intindi kung anong authenticate, di huwag kang mag-abogado dyan. I am deeply disappointed that on at least 3 occasions, the prosecution claimed that these documents came from an anonymous source. Strike me dead. 3 times is just too much coincidence. Are you for real prosecution? Falsus in uno, falsus in omnibus. False in one thing, false in all things. The defendant used his own name in all his question transactions. He could have done otherwise if his purpose was invisibility. Kung ayaw niyang matuklasan, kadali-dali. Di gamitin niya pangalan ng iba. Lahat naman kayo, hindi naman lahat. Marami sa atin dito, kung tungkol na sa batas, ibang pangalan ang ginagamit. Sigurado ako niyan. RTC judge ako eh. Mag-isa lang akong RTC judge dito sa korteng ito. Maski ano, pwede mo manufacture sa Pilipinas. Minsan, binigyan pa nga ako ng death certificate ng kusado. Pagkatapos, minahuli ko, huling-huli, buhay na buhay. Ganon ang ating korte dito. Huwag na kong padara ng kalukuhan ninyo dahil alam na alam ko yon. Kayo, nag-practice kayo, 1 taon, 2 taon. Ako, RTC judge. Why would a suspected criminal leave his calling cards at the scene of the crime? Kung noon pa, gusto pala niyang itago ang kayamanan niya, bakit niya ilagay sa pangalan niya? Marami dito sa Pilipinas naglalagay sa ibang papangalan ng ibang tao. Hindi kaya alam ng abogado yon? May master's pa sa Harvard, may doctorate pa sa UST. Ganun kaya siya katanga? Assuming for the sake of argument that there is a preponderance of evidence for the prosecution, the preponderance is not overwhelming. Yan ang Ingles. Hinada ko para sa 2 minutes ko. Wala pala kaming limitasyon. Ngayon Tagalog naman at hingi na ako ng paumanhin abansi pa lang dahil kulang na kulang Tagalog ko. Unang punto, kung matalo ang Chief Justice dito, di ang ibig sabihin pala, ang mga nananalo ay mga honest na tao dahil kinundina nila dahil corrupt yung taong yon. Di, palagay din natin na itong mga representante, dahil lahat tayo, we represent the people, isn't that so? That's why we are elected officers. We're supposed to represent our constituencies. Kung hatulan nating may sala yan, di ibig lang, dahil crooked siya, di ibig lang sabihin tayo, honest tayo. Ngayon, kung lahat pala tayo honest, o marami pala tayo sa atin ay honest, why is the Philippines often, or if not all the time, why is the Philippines always ranked as one of the most corrupt countries in the whole world? Yan, sagutin niyo ako niyan. Nagpapakalinis kayo? Aba kung malinis pala ang mga opisyalis natin at malinis pala sa buong bansa, bakit palagi tayong nililista ng Transparency International as one of the most corrupt countries in the world? Magtitinginan tayo? Sino kaya dito? Yan ang unang punto ko. Pangalawa, tumigil na kayo ng kapapangkapan nyo, mga artista. Merong mga politiko na alam natin kung anong loopholes nila sa SALN. Deposito ang sinasabi ng batas pagkatapusan ng Disyembre, katapusan ng taon. Magdeklara ka kung magkanong pera mo sa bangko. Hindi ba gini-withdraw nila pera nila sa buwan na Nobyembre o Disyembre? Para pag naglagay sila, pag nag-file sila ng SALN nila, wala nga silang deposito. O kaya meron lang sila ng couple of thousands. Kasi withdraw nila eh. Pag Enero, i-deposit nila uli. Taong bayan, kayo ang magtestigo. Yan. Ba't hindi natin habulin yung ganon? Pangalawa, palusot. O pangalawa, na ginagawa nila na loophole sa SALN. Lahat ng pag-ari nila, real estate, bank accounts, iba pang pag-ari, nalagay sa ibang pangalan. Yan is very, very widespread. O di wala nga naman silang pag-ari. Dahil lahat, linagay na nila sa ibang pangalan. Kung bawal ang asawa at ang mga anak, dahil sa batas ay inspeksyonin pati yan, yung mga malapit sa kanila, di doon sa mga malalayo ng mga kamag-anak. O kaya maski hindi kamag-anak, sa kaibigan na pinagkakatiwalaan nila. What a hypocritical accusation. That is the problem with this country. We're all for honest government, and yet the world condemns us as one of the most corrupt countries in the world. That's why it is difficult to win in any international election, in any international campaign, because the Philippines, among others, has a reputation of being a corrupt country. Isip ng iba, kung corrupt ang bayan na yan, walang matinong lalabas dyan. Walang matinong ibubunga yan. Ba't bawat isa ba sa inyo, walang sala tungkol sa SALN? Bigyan niyo ako ng isa pang buhay. Panginoon, bigyan mo ako ng isa pang buhay at imbestigahin ko lahat. Isa-isa. dito sa Senado at sa House of Representatives. Tignan natin. Pati sarili ko, imbestigahin ko.
Order, please.
Ang daming loopholes ng SALN na yan. Ba't hindi kayo umimik noon? Ba't ngayon bigla na lang kayong so exercised about a loophole? Well, if that is the case, then let us all just put our assets in dollars and know the purpose of the SALN will be perverted or corrupted. That is true. But what about all the other loopholes? Bakit ngayon lang kayo nagalit tungkol sa loophole na yan? Bakit doon pa? Dahil yung iba sa atin, ginagamit yung mismong loopholes na yon. Hindi lang sila ma-impeach. Sunod na punto. Sinabi ko sa umpisa, this is quasi-judicial and this is quasi-political. Yan, aminado yan ng mga authors. Si Professor Charles Black ng Yale, si Professor Raoul Berger ng Harvard. Mga tinitingala yan ng mga authorities all over the world. Ngayon, this is quasi-judicial. Ibig sabihin, kalahati niyan politika. Kalahati yan batas. Napakahirap gawin yan. Ngayon, ako, dahil naging RTC judge, ang ginagamit ko lang ang batas. Wala akong ginagamit na pampolitika dahil hindi na ako makatakbo ulit. Natawag na ako ng International Criminal Court. Wala na akong kinabukasan sa politika sa Pilipinas. Even if I wanted to, I am prohibited because this is already my second term, consecutive term. Ngayon, ano bang sinasabi na quasi-political? Investigahin nga natin for future impeachments. Anong sinasabi na quasi-judicial, quasi-political? Madaling intindihin ang quasi-judicial. Kalahati niyan tungkol sa hustisya o tungkol sa batas. Pero kalahati yan tungkol sa politika. Anong ibig sabihin ng tungkol sa politika? Tungkol sa politika, dahil ang ibig sabihin dyan, pag-isipan mo at pakinggan mo ang mga taong bumoto sa iyo. That is actually the meaning of quasi-political. Because the people might disagree with what the law says. Yon ang pakikinggan mo. That is the meaning of quasi-political. Hindi ibig sabihin quasi-political na buboto ka, ulit bibigyan ka ng mamahaling proyekto sa public works na kung saan maaaring kumita ka. Alam naman natin yan. Kung magkano ang halaga ng public works mo, 10% punta sa iyo kung gusto mo. Hindi iyon ang ibig sabihin na politika. At hindi ibig sabihin na quasi-political na isipin mo, nako, tatakbo ako. Either for re-election or for another position, or I need some position in government for my kalyado ko, who I will use as my dummy. That is not the meaning of quasi-political.
May I request the lady to wind up this?
I thought that I was unlimited. I prepared a 2-minute paper, but I will obey the injunction. Tsaka, isang punto. Nang nagtapos magpresenta ng ebidensyang prosecution, naglabas ng mga survey ng mga tao gusto pala na guilty ang Chief Justice. Ngayon natapos ang depensa, saan ngayon ang mga survey? Wala. At huli sa lahat at pinakamahalaga, anong magiging, hindi lang importante kung anong magiging desisyon natin ngayong hapon, anong magiging katuparan, anong susunod sa ating desisyon. Ulit ba mananalo tayo sa botohan? Panalo na tayo sa masa na nakakarami sa ating bansa. And we follow the rule of the majority. Sa kabataan sa pamantasan, dahil they're an educated constituency, sa kaysaysayan ng ating bansa, this will go down in history. Nagtrabaho ako abroad. Nagka-cancer ang tatay ko. Bumalik ako. Sabi ng tatay ko, mag-resign ka nga dyan sa trabaho mong yan. Wala kang silbi sa bayan mo. Magsilbi ka sa sarili mong kababayan. Nagsilbing na nga ako. Pero kung ang politika ay mangigibabaw sa batas, wala na rin akong silbi. Bayan, kayo ang maghatol sa ginagawa dito sa impeachment trial.
What's your vote?
Would you be very surprised if I say that I vote not guilty?
Honorable Senator Judge Drilon.
Mr. President, the Constitution commands every public official, including the respondent Chief Justice, to file an accurate and complete SALN. This requirement is not a mere formality, as it goes into the heart of a public official's and respondents' moral fitness to hold public office. Respondent concealed his luxurious condominiums for 5 years after they were fully paid. Respondent reported the values of these condominiums at less than 50% of their acquisition cost. Respondent admits that he did not declare $2.4 million and 80 million pesos in his SALN. The enormity of the respondent's hidden assets, over 180 million pesos, or 50 times more than his declared cash assets, is scandalous. It is grossly disproportionate to his total income for 10 years of about 27 million pesos. It establishes a prima facie case of ill-gotten wealth under the Anti-Graft and Corrupt Practices Act. 180 million pesos. Res ipsa lucetur. The thing speaks for itself. Respondent justifies his concealment of his dollar accounts because of the alleged confidentiality in Republic Act 6426. This kind of interpretation, Mr. President, will encourage aspiring thieves in government to simply hide all their loot in FCDU accounts. The law does not prohibit respondent from disclosing his foreign currency deposit. What the law bars is for a bank to disclose these foreign currency deposits without the consent of the depositor. In fact, the respondent authorized this impeachment court to inquire into them. How can the respondent, the Chief Justice no less, claim good faith in asserting such a twisted interpretation of the law? Besides, Mr. President, the defense of good faith cannot be invoked. The punishable act of non-reporting of assets in one SALN is mala prohibita, where good faith is immaterial. Respondent concealed his 80 million peso deposits because allegedly they are commingled funds of BGEI and that of his relatives. Respondent presented no evidence to substantiate his claims. If BGEI funds are held in trust, respondent must report such funds as assets and enter the corresponding liabilities in his SALN. He did not. He cannot claim good faith. He was the manager of SGV's tax department. The Supreme Court dismissed Delsa Flores, a lowly court interpreter, for not reporting in her SALN her stall in a public market. The Chief Justice must be held to a much higher standard. Those who dispense justice must conform to the highest standards of professional integrity and personal honesty. Chief Justice Corona knowingly, deliberately, and with malice aforethought filed inaccurate and false SALNs to conceal his enormous wealth. Where our Constitution and our laws require disclosure, he chose the path of concealment. He has lost his moral fitness to serve the people. He has betrayed the public trust. He cannot be Chief Justice a minute longer. I find the respondent guilty of Article 2.
Thank you.
Honorable Senator Judge Escudero.
It is written, "Do not judge lest you be judged, for the measure you measure with will be measured back to you." Mr. President, distinguished colleagues in the Senate and the House, the prosecution and defense panels, my countrymen, magandang hapon po sa ating lahat. While I do not approve of the manner and way by which the House of Representatives initiated, proceeded, and handled this impeachment, when they filed the complaint for impeachment before the Senate, the House, in the exercise of its constitutional mandate, in the exercise of its wisdom, determined that non-declaration in one salin is an impeachable offense. Ibig sabihin po nito, mula ngayon, dahil sa pagdeterminang yan ng Kamara de Representantes, pwede na nating tanggalin ang punong mahistrado, kabilang ang Pangulo at ikalawang Pangulo ng bansa, gayon din ibang mga impeachable officers kapag ka sila ay merong ari-arian na hindi dineklara sa kanilang salin. Mr. President, matapos po aminin ni Chief Justice Corona na meron siyang $2.4 million at 80 million pesos na hindi niya dineklara sa kanyang salin, naging simple na lamang ang kailangang pagdesisyonan at pagpasahan ng Senado. At ito po ay, hindi nga ba ito kailangan ideklara dahil sa Republic Act 6426 o FCDU law? Kung sasang-ayon tayo sa posisyong ito ni Chief Justice Corona, dapat natin siyang ipawalang sala. Subalit, kung di tayo sasang-ayon dito, dapat ay gawaran natin siya ng hatol. Ikinalulungkot ko po, Mr. President, na di ko masasang-ayunan ng posisyong ito ng punong mahistrado. Para sa akin, maliwanag ang batas. Hindi po ito nagbabanggaan. Ang pinagbabawalan ng FCDU law na mag-release ng impormasyon tungkol sa dollar accounts ay ang bangko at hindi ang depositor. Samantala, ang ating saligang batas at Republic Act 6713, pinag-uutos na ideklara ng lahat ng naninilbihan sa pamahalaan ang lahat ng kanilang yaman at pinagkakautangan. Kung ayaw ninyong ideklara, edi huwag kayong tumakbo para o tumanggap ng anumang pwesto sa gobyerno. Subalit kung ikaw ay naninilbihan sa pamahalaan, dapat lang at kailangan ideklara mo ang lahat ng ito. Dahil dito, mabigat man sa aking kalooban, kailangan kong magawad ng hatol laban kay Chief Justice Corona. Maging ganun pa man at sa kabila ng aking hatol, nais ko pong muling batiin si Chief Justice Corona dahil sa kasaysayan ng ating bansa, siya ang alam kong kauna-unahang opisyal na naglakas loob at nag-execute ng waiver para buksan ang lahat ng kanyang mga deposito sa bangko. Sana po siya at ang kasong ito ang magsilbing hudyat para sa isang bagong simula sa ating bansa. Isang bagong simula kung saan hindi na pwede ang dating gawi. Hindi na pwede ang dati nating nakasanayan. Panahon na po ito marahil na taasan natin ang antas ng pamantayan ng mga naninilbihan sa pamahalaan. At dapat po pantay ang pamantayang ito hindi lamang kay Chief Justice Corona, kung hindi para sa ating lahat. Kahapon isinumite ko sa Senado ang isang waiver pabor sa Ombudsman upang buksan kung kinakailangan ang anumang deposito ko, dollar man o anumang uri ng currency, kaugnay at kalakip ng aking salin. Hinihimok at hinahamon ko ang lahat ng aking kasamahan sa Senado, gayon din sa Kongreso, na gawin din ito. Hinihiling ko rin sa aking mga kasamahan sa Senado at sa Kongreso na ipasa sa lalong madaling panahon ang iniakda kong Senate Bill 107 na naglalayong i-require na ito sa ating lahat. Hindi simpleng pagtanggap ng hamon, kung hindi aktwal na pagpirma. Tulad po ng sinabi ko sa aking pambungad na salita, kung ano man ang panukat na ginagamit natin sa paghusga o pag-akusa, siya ring panukat na dapat nating gamitin sa ating mga sarili. Ika nga ni Congressman Fariñas, kung di natin pinapalusot si Chief Justice Corona, pues tayo din wag nang magpalusot. Ito'y hinihiling ko para magkaroon po ng saysay, kahulugan at positibong kinakahinatnan ang kalbaryong pinagdaanan di lamang ni Chief Justice at ng kanyang pamilya, kung hindi ng ating bansa, bungsod ng proceedings na ito. Dalangin ko po na sana matapos ito, magsimula na maghilom ang pait, sugat at pagkawatak-watak natin. Sana naman po, pagkatapos nito, tama na. Magtrabaho na tayo, let us move on and let us move forward. Pagtuunan na po natin ang pansin ang mas mahalagang problema ng ating bansa na may kinalaman sa ekonomiya at paglagay ng pagkain sa bawat lamesa. Tanggap at nalalaman nating lahat. Ano man ang hatol na igawad ng hukumang ito, hindi naman biglang magkakatrabaho yung walang trabaho at hindi naman biglang gagaling ang may sakit. Hindi biglang makakapag-aral ang hindi kayang makapag-aral at hindi gaganda ang buhay ng ating mga kababayan. Mr. President, ano man ang maging hatol natin sa hapong ito, nais kong sabihin to the Chief Justice and his family, I wish you well. Naway gumaling po kayo sa inyong karamdaman sa lalong madaling panahon. Patnubayan nawa kayo at tayong lahat ng Diyos, kaugnay na malaking hamon at pagsubok na sabay-sabay po natin kinaharap at pinagdaanan nitong mga nagdaang buwan. Mr. President, on Article 2, I find for the complainants and render judgment against the respondent, Chief Justice.
1 minute suspension.
So sa kasalukuyan po, nakikita natin yung score sa TV screen natin na
5 guilty, 2 not guilty, 0 abstain. Ang kailangan to convict ay 16 votes.
16.
No?
At sa
and
kabila
then 8
naman,
votes to acquit. So far, ano hong masasabi
dinagapin mo ang yung argumento pa rin, no, kung impeachable offense o hindi. Consistent si Senador Miriam at Arroyo, isa yung direksyon na kino-question yung naging proseso dito, no? Pero yung 5 naman ay naniniwalang dahil Chief Justice siya, may high standard siya pagdating sa public accountability.
Oo. Yeah. Kasi medyo mas mataas ang standard na linay down ng Supreme Court para sa mga judges and justices kaysa sa ordinary elective officials Kasi yung mga judges and justices they are not subject to the people's decision every election year.
Opo.
They are answerable only to their conscience and therefore they are not they do not feel really accountable to the people.
Okay. Professor, yung mga lumitaw na mga pangalan, di ba kayo nagulat dyan? O inasahan na yan ang mga magbibigay ng guilty vote, tapos itong dalawang si Senator Joker at Santiago ang not guilty vote?
Siguro, Professor Morales, it's interesting to note kung ano ang magiging future political plans ng mga nagbuoto na not guilty. No? I guess hindi na re-electionist sina Miriam and Joker Arroyo. Miriam is moving on to the International Tribunal.
Walang political risk,
yes,
no?
So, are we trying to suggest here na may mga political futures pa so far, no? Yung mga bumoto ng guilty.
Meron ba? Meron ba po?
I don't know. I don't know what their political plans are, but it would seem like, di ba, may mga binitiwan na silang salita na may mga... Well, alam mo, more or less inaasahan naman natin so far na ganito magiging botohan. For a while, I wasn't sure about Senator Escudero.
Yes.
I really wasn't sure. In fact, naghihintay ako kanina na sige, ganyan. But is it impeachable? Hindi siya nagpunta doon. But sure, they're entitled to all of their opinions. As a matter of fact, tama yun. This is a political exercise.
Ano pa sa palagay nyo yung magiging question mark dito sa mga susunod na boboto? Bong Marcos, we don't know also for sure. No? I mean, ano pa yung mga ibang inaabangan nyo?
More or less, iniisip natin nun, ano kaya yung mga political affiliations, ano kaya ang magiging mga plans for their political future dahil, maski pa paano, nag-iisip sila ng ano kaya ang sasabihin ng aking constituency? Susuportahan ba ako dito sa magiging decision ko? And it's very important for the senators na masuportahan sila ng mga nanonood, ng publiko sa kanilang mga desisyon. For those who have political futures. I don't know about whatever futures they have in mind.
Si Senator Miriam, doon sa process, parang may mga complaints siya din. Bilang RTC, yun ang proseso sa korte niya. Pero sinasabi din natin, tumatayo na po si Senator Jigo Estrada, nagpapaliwanag po ng kanyang boto.
Magandang hapon po sa lahat. This trial and this court, the entire process, its completion is a historic redemption of our justice system. We owe that in great measure to the brilliance, sense of fairness, and firm resolve of our presiding officer, no less than the Senate President Juan Ponce Enrile. I say redemption because this same process failed to achieve justice for my own father, former President Joseph Ejercito Estrada. It failed because clearly the plan was to resolve the issue in the streets. And it failed, sadly, because the presiding officer at the trial of my father proved to be a partisan himself. Those sordid accounts, those sordid events led this nation to 9 years under the rule of a woman, a small woman who was installed by the rule of the mob and the imprimatur of a Supreme Court that succumbed to the pressure of that mob. I am more than sure that my father would have been given the chance to be heard fairly, justly, and squarely, katulad ng pagkakataon ipinagkaloob ng impeachment court na ito kay Chief Justice Corona. Had the impeachment rules been strictly implemented then in 2001, those private prosecutors who disrespected this court by walking out, thus robbing my father the chance to defend himself, would have not been allowed to do so, much less be held in contempt. Now, today we confront and make history. We make a historic decision this day to pass judgment on the Chief Magistrate of the Supreme Court of this nation after 44 grueling days of trial spread out in 4 difficult months. Our people followed this trial closely, and in this exercise we have demonstrated to them and to the international community that our country adheres and subscribes to the supremacy of the democratic framework and the majesty in fulfilling the mandate of the most basic of all our laws, the Constitution of the Republic of the Philippines. Sa paglilitis natin isinagawa sa harap ng sambayan ng Pilipino, itinaguyod natin sa ating Senado ang itinadhana ng ating saligang batas. Binigyan buhay natin ang diwa ng mga proseso ng ating batas at binigyan natin ng patas na pagdinig ang panig ng taga-usig at ng nasasakdal. Today, I join the nation in a fervent prayer that we can begin healing the wounds inflicted by the pain of this trial. We pray that we can, as soon as possible, bring closure to this painful episode in the annals of our country. I pray that as we conclude this defining moment, we can unite again as a nation, as a society, and attend to the many pressing problems that face us. I take the view, after hearing the arguments and counter-arguments, that the Chief Justice did not include in his statement of assets and liabilities and net worth his SALN, $2.4 million and 80.7 million pesos. This he admitted in open court. Napatunayan ng depensa
na hindi 45 properties, kung hindi 5 lamang. Hindi $82 million, hindi $82 accounts, kundi 4 lamang. At hindi 10, 11, 12 million dollars, kung hindi $2.4 million lamang. But these numbers are irrelevant because the most important question is, itong 5 real properties, 4 na dollar accounts na may halagang $2.4 million ba ay dineklara ng tama? Dineklara ba ito sa takdang oras o panahon? Ang sagot ko po ay hindi. It was argued by the defense panel that the non-inclusion of dollar deposits by the Chief Justice in his Sal-N was made in good faith and is covered by the provision of absolute confidentiality under the Foreign Currency Deposits Act. I regret to say that I am not convinced because the Chief Justice is a learned man of law. He is in fact the Chief Justice of the Supreme Court. Isang opisyal na hindi lamang malalim ang kaalaman sa batas, kundi isang opisyal na may tungkulin basahin kung ano ang ibig sabihin ng mga batas. Bilang punong mahistrado, siya ay dapat na may higit na kaalaman at pag-unawa sa diwa ng batas at tungkulin niyang ipatupad ito na walang bahid ng pagtatakip sa pansariling interes. And I believe that the framers of the Foreign Currency Deposit Act did not intend to create the opportunity for public officials to conceal their assets or stash away foreign currencies under this law. I therefore make this painful decision with a heavy heart, but confident that we have given justice to our people. Sa kadahilanang ito, wala akong pag-aalinlangan ngayon nang nasasakdal ay nagkasala at lumabag sa itinadhana ng ating saligang batas. Sa wikang Ingles, in my eyes, he is guilty. Maraming salamat po.
Honorable Senator Judge Gingona.
Mr. President, before I proceed, I'd just like to manifest that I will be submitting after my explanation a more comprehensive written decision which will form part of the records.
Granted.
Ginoong Pangulo, sa paglilitis na ito, ang aking boto ay para sa kasagraduhan at kapangyarihan ng saligang batas ng Republika ng Pilipinas. Mr. President, if there is one thing that our nation would have learned in this impeachment process, it is this, that we must renew our respect for and protect the sanctity and primacy of the Constitution of our Republic. Ang ating saligang batas ay sagrado at walang sino mang kapangyarihan sa ating bansa ang mas mataas pa dito. Ito ay sagrado, lahat dito ay dapat sumunod. Ipatupad ito at igalang ito. Ito ay sagrado, kaya lahat ng lingkod bayan, ibinoto o inappoint man sa tungkulin, ay pinasusumpa na ito ay itataguyod at ipagtatanggol. Ang hindi pagsunod, ang hindi pagtupad, ang hindi pagtatagol sa ating saligang batas ay isang malinaw na paglapastangan sa pinakamataas na batas ng ating Republika. At sa kaso pong ating nilitis, Ginoong Pangulo, pinag-aralan ko ang mga sumusunod. Nagkaroon ba ng paglabag at paglapastangan sa sagradong saligang batas ng Pilipinas? At kung nagkaroon nga, ang lumabag at lumapastangan ay dapat bang hindi na payagang manatili sa kanyang pwesto at tungkulin? Inahayag ba ng nasasakdal ang lahat ng assets, liabilities at net worth niya bilang pagsunod sa utos ng saligang batas? Ang sagot ko po, hindi po ginawa. Nagkaroon ba ng bahid ang kanyang integrity at probity sa panahon ng kanyang panunungkulan sa pinakamataas ng korte ng ating bansa? Ang sagot ko po, opo, nagkaroon po ng malaking bahid. Nilabag ba niya ang utos ng saligang batas na siya ay dapat maging accountable to the people sa lahat ng pagkakataon at maglingkod ng may utmost responsibility, integrity, and loyalty? Ang sagot ko po, opo, nilabag po. One of the action of the accused stands out, Mr. President. Mula mismo sa mga labi ng nasasakdal, inamin niya na nakadeposito sa iba't ibang mga bangko ang mga salapi niya na nagkakahalagang 80 milyong piso at $2.4 million. Pero nasaan ito? Nasaan ito sa kanyang sinumpaang statements of assets, liabilities, and net worth? Idedeklara lamang ba ito kung kailan gugustuhin ng isang mataas na opisyal? Pwede ba siyang magtago sa likod ng Foreign Currency Deposits Act? Mr. President, ito ay isang pagbaluktot ng provision ng Konstitusyon. How can one man use the very same Constitution which mandates full public disclosure to justify concealment of millions of dollars in his personal bank account? This is constitutional perversion in its ultimate form. Ginoong Pangulo, sino ba ang inaasahan ng ating bansa at lipunan para maging pangunahing tagapagtanggol ng saligang batas? Hindi ba't ang Korte Suprema? Anong aasahan natin pagtatanggol kung ang mismong pinuno nito ang unang humahanap ng butas para baluktutin ang ating saligang batas? Ang saligang batas ay sagrado. Ano man paglusot sa mga utos nito, ano man pagbaluktot dito, ay paglabag at pagbabastos sa pinakamataas na batas ng bansa. The Constitution above all. Ginoong Pangulo, batay sa ebidensya, sa mga mismong mga sinabi at pag-amin ng nasasakdal, at bilang pagkilala sa kasagraduhan ng saligang batas ng Pilipinas, ito ang hatol ko. Ang nasasakdal na punong mahistrado ng Korte Suprema ay hindi na po karapat-dapat sa pagtitiwala ng sambayanang Pilipino. Mr. President, I vote to convict the accused Chief Justice of the Supreme Court. Maraming salamat po.
Secretary.
Honorable Senator Judge Honasan.
To our countrymen, my fellow Filipinos, Mr. President, distinguished colleagues, honorable members of the prosecution and defense panels. From the beginning of this trial, I have been looking for a reason to acquit. Based on compassion, based on the basic precept that a man is innocent until proven guilty beyond any reasonable doubt, and based on my own personal experience. I know what it is like to have my family maligned and to be deprived of due process. That being said, this trial is not about personalities, emotions, or partisan politics. This is about judging whether the highest magistrate in the highest court of the land is fit for the job. Is his integrity beyond any doubt? Is his understanding of the law absolute? and beyond question, as the position demands. At every moment in his legal career, did he speak out against injustice and uphold the law, rising above us all. An institution is only as strong as its leader. And we, senator judges, are only extensions of the will of the people. We have gone through the process to bring us as close as possible to certainty. It is my opinion that we have not proven if the defendant is corrupt or if he is malicious. What is clear is that based on the doubt cast on his capability to dispense justice and to do his duty, he is no longer fit to preside over the highest court in the land. Ang malinaw po ngayon ay may duda na sa kakayahan ng ating punong hukom. Doubt is the opposite of faith, and faith is the source of hope. Doubt does not happen in our brain where reason lives, but in our hearts where our moral compass rests. I vote to ask the Chief Justice to step down from the pedestal where he was installed by the nation and where he was supposed to preside over the highest court in the land, so he may once more walk among our people, where all public officials must be judged. Bumalik na siya dito sa atin, sa piling ng taong bayan, para maranasan niya ang bunga ng kanyang pagkukulang. Sambayan ng Pilipino, ang hatol ko po ay guilty. Mr. Chief Justice, I wish you strength and honor. Thank you, Mr. President.
Honorable Senator Judge Lacson.
When a witness takes the stand, he swears to tell the truth, the whole truth, and nothing but the truth. That makes half-truths no better than lies. I have always been an investigator all my public service life. Modesty aside, I have the uncommon ability to determine if a person is telling the truth or not. An error in judgment has no place in this trial because it is final and irreversible. Equally important to me is the testimony of the respondent, particularly in this case, because the exalted position of the highest magistrate of the land must shut its door to anyone who desecrates the solemn oath that engulfs a testimony in any judicial proceeding. Over the weekend, I did my homework and discernment. Let me share it with you. Chief Justice Renato Corona at one point had $3,977,790.87. At a given time, he had 91,280,499 pesos and 22 centavos. If you ask me, so what is the difference between 3.9 million and 2.4 million US dollars? Between 91 million pesos and 80.7 million pesos? My answer is a lot of money. Chief Justice Renato Corona used to work as a senior officer of the Tax and Corporate Counseling Group of the Tax Division of a prominent accounting firm, Sisip, Gores, and Belayo and Company. He also taught commercial law, taxation, and corporate law at the Ateneo de Manila University for 17 years. I find it hard to believe his testimony that he does not understand accounting. Chief Justice Renato Corona testified under oath that he invested in currencies and not in properties in the late 60s, mindful of the Basa Guidote family squabble over some real estate properties left by their deceased parents. The fact is, the family feud started in 1989. One cannot simply learn from the lessons of the future, even if the standards of moral fitness for such a lofty position in government were lowered. An acquittal may still be difficult to justify. Mr. President, distinguished colleagues, I therefore find the respondent guilty as charged under Article 2 of the Articles of Impeachment.
Secretary.
Honorable Senator Judge Lapid.
Hi, Mark. Magandang hapon po, Senate President. Kasamahan kong Senador, Judge, Prosecution, at Depensa. Sa ating mga kababayan na nanonood at nakikinig sa TV at radyo, inuulit ko magandang hapon po sa inyo lahat. Alam niyo po, wala man po akong speech dito, wala po akong dala. Yung mga kasamahan ko dito, pag pinasok sa isip nila, dadalhin sa bibig at maganda na ang sasabihin. Bilang high school graduate po, sa ating mga kababayan, anong sasabihin ni Lito Lapid na hindi marunong mag-English, na hindi kaalam sa batas? Ano kaya ang magiging desisyon? Didesisyonan po ang kataas-taasang hukom ng isang high school graduate lamang na tiga probinsya ng Pampanga. Napakinggan ko po ang depensa. Siguro purihin po natin ang depensa. Napakagaling nila sa mga nakakaintindi ng mga abogasya. Purihin din po natin ang prosecution. Naghanap ng mga ebidensya. Nakinig po ako sa bawat ebidensyang inaano nila dito. Ngayon, naayon po, lalong-lalo na si Congressman Pariñas, yung pong pinirsinta niya kahapon dito, para sa akin lang po, ay malinaw na si Chief Justice Corona ay lumabag sa batas. Siya mismo inamin niya na may $2.4 million at 80 million pesos na bank account. Yun po siguro hindi na kasinungalingan yun. Yun po ay totoo na. Nagpipresenta po ako dito hindi bilang abogasya. Hindi po ako pwedeng magsalita ng Republic Act dahil hindi maniniwala ang tao sa akin. Hindi po ako nagmamarunong-marunong dito. Ang ginagamit ko lang po dito, konsensya. Representante ng masa na hindi nakapag-aral, hindi marunong mag-English, ni walang alam sa batas. Kaya, nung pong nagsasalita dito, si Chief Justice Corona, nagsusumbong sa taong bayan. Awang-awa po ako sa kanya. Akala ko totoo sinasabi niya. Hindi pala. Mas pinaniwalaan ko pa si Congressman Pariñas nung nag-PowerPoint dito. Ngayon, ang sinasabi niya ay isang pizza pie. Hindi po totoo yan na may 82 akong account. Siguro kung ako ang pagbabasihan ko, kung 100 basong tubig linagay sa 4 na drum lang ang kanyang account. Naawa po ako sa kanya dahil naintindihan ko po kung anong damdamin niya at sa kanyang pamilya. Nararasan ko rin po yan. At sana
Pagkakataon ito, pasasalamatan ko siya. Dahil nung pangalawa kong panalo bilang senador, sa kanya ako nanumpa bilang isang senador. Pasensya na po. Pasensya na po. Ang hatol ko sa inyo, guilty.
Honorable Senator Judge Ligarda.
Please maintain decorum in this court. We do not want to be disturbed.
Mr. President, sambayanang Pilipino, hindi po madaling humusga ng kapwa, lalo na kapag ang nasasakdal ay ang punong mahistrado. Mahirap pong humusga sapagkat tayo ay tao lamang. Ngunit ito po'y isang sagradong tungkulin na ating dapat gawin. It is a sacred mandate I must keep, and I do it in all honesty and sincerity, without anything in exchange, without bending to any perceived pressure, but born out of intensive study, contemplation, and prayer. Mr. President, while we ponder on the 3 articles of impeachment, the most robust documentary and testimonial evidence and debates have centered around Article 2. I therefore select Article 2 as the anchor of my verdict because I hold that public and truthful disclosure of assets, liabilities, and net worth by a public official is a key and fundamental element of governing through the norms of transparency and accountability, and a centerpiece principle of democracy. Disclosure of SALN is the only window by which the public can judge whether or not we have undeservedly enriched ourselves in public office. Through it, we, as public officials, earn public trust. Public trust is not simply an administrative entitlement by those in government. Mr. President, I am disappointed that concessions of disclosure of SALN and the waiver of bank secrecy have only been belatedly and calculatedly done when these have been rendered moot by the practical turn of events. I also believe that interpretations in the wordings of the law should not obscure the charge of betrayal of public trust supported by evidence. For public trust is earned through transparent, often voluntary gestures of honesty by officials in question, and not solely by legal argumentation, no matter how sophisticated. In casting my vote, Mr. President, my chief concern is the credibility and the trust of our people in the most important institution of our land, whose mandate is to interpret the law and render wise and fair judgment equally to all. Sa dinami-rami po ng mga argumentong legal, ebidensya, at pati na po ng napakaraming PowerPoint presentations na inilatag ng prosecution at ng depensa sa paglilitis na ito, isa pong kaso na hinatulan ng Korte Suprema noong 1997 ang tumawag sa aking pansin. Ito po yung kaso ng isang kawani ng hudikatura, isang interpreter sa Regional Trial Court na siyang tinanggal sa serbisyo dahilan sa hindi niya nadeklara ang kanyang negosyo sa palengke sa kanyang salin. Ginoong Pangulo, kung ang ating mga batas tulad ng Republic Act 6713 ay nagpaparusa ng dismissal sa isang ordinaryong kawani ng gobyerno sa paglabag ng mandato upang maiwasan ang katiwalian, wala po akong nakikitang dahilan para po hindi ipatupad ang parehong batas na ito sa isang punong maestrado. Mr. President, we are all guided by the basic principle of equal application of the law. And in Thomas Jefferson's own words, and I quote, "It is certainly for the good of the whole nation to deal law and justice to all by the same rule and the same measure." If we acquit the Chief Justice, we would tragically lift the floodgate for public suspicion and widespread distrust on the highest institution of our judicial system. We also lower the bar of public accountability of government officials. It was not easy. It is painful, but we must do it. I therefore vote for removal from public office. I vote to convict.
Honorable Senator Judge Marcos.
Mr. President, ladies and gentlemen, the Lady Justice wears a blindfold for a reason. She is to render judgment based on law and evidence without regard to the circumstances and personalities of the parties involved, however controversial they may be. She is to dispense justice without fear or favor. We here all took an oath to do impartial justice according to the Constitution and the laws of the Philippines. And like Lady Justice, we are bound to do so without fear or favor. An impeachment trial is sui generis. But be that as it may, the Bill of Rights stands supreme over all the powers of government, including the power to impeach. And nowhere is this precept more apposite than in this case, where the government has mustered all the resources at its disposal, not only to secure evidence against the Chief Justice, but further to ensure his conviction. The crucial issues that have piqued the interest of the senator judges, as well as the public, were outside the original ambit of the impeachment complaint and have been brought forth only after its filing. Evidence on some of these issues came from questionable sources, beginning with the unidentified little lady to documents anonymously left on gates and in mailboxes. At the expense of the sub judice rule, evidence had been presented to the public on several occasions, even before they were formally offered before this court. Worse, information was grossly exaggerated with the apparent intention to predispose the public mind against the Chief Justice. Notable examples would be the Land Registration Authority report with a discredited list of 45 properties and the unauthenticated AMLAC report claiming that the Chief Justice allegedly owned $10 million. Still, the Chief Justice sufficiently addressed the accusations against him with regard to the filing of his salin and the disclosure of his real properties and pesos deposits. Relative to his dollar deposits, the Chief Justice believed that he was under no legal duty to declare these deposits pursuant to RA 6426, which affords absolute confidentiality to all foreign currency depositors. This interpretation of the law is now being publicly criticized as flawed. However, it is known to all of us that quite a number of public officials construe RA 6426 vis-a-vis RA 6713 in exactly the same manner. In view of the ambiguous situation created by the concurrent application of the 1987 Constitution, the Salen Law, and the FCDU law, and absent a determinative judicial pronouncement that resolves the contrary positions on this legal issue, the Chief Justice must be presumed to have acted in good faith. Indeed, it has been held that not all omissions and misdeclarations in the Salen amount to dishonesty. The framers of the Constitution intended culpable violation of the Constitution to mean a willful and intentional violation of the Constitution. Betrayal of public trust, on the other hand, was meant to be a catch-all phrase to encompass all acts violative of the oath of office or which render the officer unfit to continue in service. Both grounds, however, were contemplated to exclude unintentional or involuntary violations, errors made in good faith, and honest mistakes in judgment. Granting, therefore, that the Chief Justice violated the Salen Law, this certainly does not rise to the level of an impeachable offense. We may be faulted for erring on the side of conservatism, but what we are doing is nothing less than redefining the relationship between branches of government. And when such great affairs of state are uncertain, the resulting instability puts every Filipino's future in limbo. This is an important, delicate, momentous event, and because of that, we should tread very lightly. We must be very, very careful and very, very fair in making this decision, because what we do today will reverberate throughout our social and political history, affecting generations beyond ours. When the furor has died down and this political storm has subsided, I know that, like Lady Justice, we shall find solace in the fact that this decision, though maybe not popular, was fair, impartial, and just. On the arguments presented and on the ground that the presumption of innocence has not been overcome, I vote to acquit the Chief Justice of the Supreme Court.
Honorable Senator Judge Osmeña.
Mr. President, esteemed colleagues, honorable members of the House of Representatives, distinguished members of both the prosecution and defense panels, my countrymen. In arriving at our decision today, we narrowed our concerns into four. 1. Did Chief Justice Renato Corona violate the Constitution? 2. Did he do it knowingly and willingly? 3. Was the violation of such gravity as to warrant his impeachment? And 4. Has Justice Corona betrayed the public trust? Ironically, the answers to the first two questions were supplied by the defendant himself. When Justice Corona admitted he had not disclosed in his yearly statement of assets, liabilities, and net worth over 180 million pesos in cash or near cash. While not in consonance with the SAL law, Justice Corona gave as his excuse the FCDU law. Yet nowhere in that FCDU law is the depositor not allowed to disclose his own deposits. All the FCDU law prohibits is that the depository banks and third parties are not allowed to disclose the account and the amount of deposits. Searching for the answer to the third question took a little longer. Is the violation of the SALN law of such gravity as to merit impeachment? Not surprisingly, the answers were again supplied by Justice Corona and the High Court. Numerous decisions on cases involving SAN law violations have been handed down by the Supreme Court. Among others, Rabe versus Flores, Concerned Taxpayer versus Doblada, Carabeo versus Court of Appeals, Office of the Court Administrator versus Usman, Flores versus Montemayor, and several others. In Rabe versus Flores, for example, the Supreme Court ruled
that a simple, humble court interpreter in Davao del Norte in Mindanao had to be dismissed from service because she had failed to disclose in her statement of assets and liabilities and net worth that she rented a market stall in the Panabo market. The High Court further ruled that Ms. Flores was perpetually disqualified from holding office. I went a bit further and posed a hypothetical question of myself. If the court had been supplied with a bank passbook belonging to Mrs. Flores, which showed a deposit of $10,000, which had not been reported in her SALN, would the court's ruling have been the same? Dismissal and perpetual disqualification from office? My plain, ordinary, legally untrained, but reasonable mind tells me yes, the Supreme Court would have ruled similarly. If these public officers had been dismissed from office for failing to declare far less remarkable, far less valuable assets in their SALNs, despite and regardless of their excuses, then there is more reason to apply the law when the assets in question amount to over 180 million pesos. We should not penalize the poor man for stealing a bicycle, but rule that the rich man must first steal a Mercedes before he is subjected to a similar penalty. My fourth and last question was, did Justice Corona betray the public trust? Again, ironically, the answer was supplied by Justice Corona and the Supreme Court. For contained in the new Code of Judicial Conduct for the Philippine Judiciary, under Canon 2, which covers integrity, are two sections. 1. Judges shall ensure that not only is their conduct above reproach, but that it is perceived to be so in the view of a reasonable observer. 2. The behavior and conduct of judges must reaffirm the people's faith in the integrity of the judiciary. Justice must not merely be done, but must also be seen to be done. Mr. President, we all must face the Miss Floreses of our country, whether in Mindanao, the Visayas, or Luzon. We must be able to tell them that justice is, to the best of our ability, being applied equally to the rich and to the poor, to the powerful and to the powerless. The Senate Impeachment Court must restore the people's faith in the judicial system. The Senate must bring about a higher level of moral standard in governance. I therefore find for the people guilty on Article 2.
Honorable Senator Judge Pangilinan.
Kagalang-galang ng mga kasamahan sa Impeachment Court. Mga kababayan, magandang hapon po sa kanilang lahat. Hindi dineklara ni Ginoong Corona ang daang milyong piso at dolyar na mga account. Hindi niya idineklara taon-taon ang mga milyong-milyong pisong pag-aari ng mga condo units. Ang hindi pagdeklara ng makatotohanang SALN taon-taon sa loob ng halos isang dekada ay dishonesty at isang culpable violation of the Constitution. Ano po ang ebidensya? Nariyan ang salaysay ng PS Bank President, ng Ombudsman, at ni Ginoong Corona mismo. 22 million ang sinabi niya sa SALN niya, ngunit halos 200 million cash ang hawak niya. Ito ba ay minor na kakulangan lamang? Dapat bang 200 bilyon ang hindi idineklara para maging mabigat ang kaso? At kung sa malinis na paraan nakuha ang mga ito, ano ang masama na ideklara niya lahat? dahil wala naman siyang itinatago. Di dapat ikaila kung walang tinatagong masama. Base sa ebidensya, maliwanag na nagkaroon ng sistematikong pagtatago ng ari-arian, sistematikong pagtatakip sa tunay na halaga ng mga ito. It pains me as a lawyer and an officer of the court to say that clearly the Chief Justice displayed a disturbing pattern of dishonesty, willful concealment, and evasion, and a blatant and wanton disregard of the provisions of the Constitution on the statements of assets, liabilities, and net worth. Sa paglilitis na ito, nakita rin natin ang pagkatao ni Chief Justice. Siya ba ay dapat pa natin pagkatiwalaan? Kung hindi po natin i-convict si Ginoong Corona, sabi po ni Speaker Belmonte, 6 na taon pa siyang uupo bilang Chief Justice. Kung kaya niyang ipagkait sa mismo niyang kamag-anakan ang kanilang ari-arian sa Basa Gidote, gayong 100 milyong na pala ang kanyang cash, siya ba ay dapat pagkatiwalaan sa loob pa ng 6 na taon? Kung kaya niyang ipakita ang kawalan ng respeto sa 23 senador nung siya ay nagtangkang mag-walk out na sa aking paniwala ay napigil lamang dahil sa mabilis na kilos ng ating mahal na Senate President. Ginawa niya ito sa harap mismo ng lahat ng media at buong bansa. Paano kaya ang pagtrato niya sa maliliit nating mga kababayan na hindi mga senador na dumudulog sa kanyang tanggapan? Siya ba ay mapagkakatiwalaan pa ba na rumispeto sa maliliit nating mga kababayan sa loob ng 6 na taon? Dapat po siya managot dahil siya po ay nagkasala. Tulad na lamang ng isang court interpreter sa Davao na sinibak mismo ng Korte Suprema dahil hindi niya iniligay sa kanyang salain ang pag-aari niyang market stall sa palengke. Tama ba na ang pagsisinungaling ng maliliit at mahihirap ay parusahan habang ang pagsisinungaling ng makapangyarihan ay absuelto? Ang pagsisinungaling ba ay impeachable offense? Si Chief Justice na mismo ang nagsabi sa kanyang talumpati sa harap ng Manila Overseas Press Club noong June 24, 2010 kung ano ang nararapat sa mga huwes na hindi tapat sa tungkulin. Sabi po ni Chief Justice, and I quote, "I believe that a member of the judiciary who is found guilty of dishonesty should not only be dismissed from the service, he should also be disbarred. No ifs or buts." Siya na po ang nagsabi na kapag ang isang huwes ay nagsisinungaling, hindi lang ito dapat sibakin sa pwesto, dapat pa ho ito madisbar bilang abogado. Sa kanyang mga labi na mismo nanggaling na nararapat siyang makonvict at masibak sa pwesto. The vote to convict is a vote to defeat abuses and excesses in government. Ang boto ng conviction ay boto upang wakasin na ang pang-aabuso at pamamalabis ng mga opisyal ng ating bansa. We all want a better, more progressive nation. We all want our nation to reach developed nation status in our lifetimes. And yes, for our children. But critical to a modern state is an effective system of justice that has the trust and faith and confidence of our people. We all want to see the end of abuses in governance. We have heard of exposés after exposés of abuses in government. We have witnessed lawlessness, criminality, corruption, and disrespect for the rule of law. Respect for the rule of law will only be realized if punishment of the guilty is swift and in a fair trial. Unless we punish more and punish swiftly, lawlessness, abuse, and disregard of our laws will not be defeated. Those who wish to abuse their offices will continue to be emboldened to commit their nefarious activities. Only when we punish the guilty and punish them swiftly in a fair trial will respect for the rule of law be restored. No less than the Chief Justice has been accused of culpable violation of the Constitution. To convict him is to uphold the rule of law. and will send the signal to the entire nation that the rule of law should be respected, and it should strike fear in the hearts of all those who wish to violate our laws and disrespect our Constitution. For this reason, I find the Chief Justice guilty.
Honorable Senator Judge Pimentel.
Magandang hapon po sa inyong lahat. Maayong hapon kaninyong tanan. Impeachment is a constitutional administrative proceeding. When there is sufficient credible evidence to prove a constitutionally recognized ground for impeachment, then the impeached high government official must be removed from office. There is evidence on record which shows that Respondent Corona did not declare in his SAL-ends for certain years real properties worth millions of pesos. There is also evidence on record, as well as admissions, that millions of pesos and millions of dollars were also not declared in the respondent's SAL-ends. The arguments of the respondent do not persuade this Senator Judge. Number one, the ownership of real property is transferred upon delivery of the real property sold. When the contract of sale of real property is embodied in a public instrument, the execution of the said instrument is equivalent to delivery of the thing sold. Number two, there is no law exempting commingled funds from disclosure in the SAL-N. Minarapat sana ng punong maestrado na iwasan ang ganitong mga alanganing transaksyon pinansyal. Hindi na nga iniwasan, ginagamit pang kasangkapan upang hindi tumupad sa kanyang tungkuling ilahad ang tunay niyang yaman. Number three, the duty of a public officer or employee to submit under oath a declaration of assets, liabilities, and net worth is mandated by the Constitution. In case of conflict, the Constitution prevails over RA 6426. Number four, the SAL-N is required by RA 6713, a 1989 law. The respondent relies on RA 6426, a 1974 law. In case of conflict, the later law prevails over the earlier law because the later law is the latest expression of the legislative will. Number five, RA 6713 emphasizes the obligation of the public official and employee to file his SAL-N, as well as the right of the public to know their assets, liabilities, and net worth. The 1974 law, RA 6426, cannot be interpreted in such a way that it would nullify the main purpose of the Code of Conduct as a tool against graft and corruption. Hindi layunin ng RA 6426 ang magsilbing kanlungan sa mga tiwali sa gobyerno. An earlier law cannot be interpreted to nullify the purposes of a later law. The respondent relies too much on the phrase, and I quote, of an absolutely confidential nature. This phrase is practically useless as the Secrecy of Bank Deposits Act itself provides 4 exceptions. Jurisprudence and other laws add 6 more exceptions. The Foreign Currency Deposit Act, the FCDA itself provides 1 exception, and jurisprudence and other laws provide for a further 2 more exceptions. How can something be of an absolutely confidential nature when there are so many exceptions to the rule of confidentiality? The 1974 Foreign Currency Deposit Act and the 1989 SAL-N law do not have to exclude each other. They can be harmonized. This Senator Judge respectfully submits that the 2 laws could be harmonized as follows. Foreign currency deposit accounts continue to be protected from idle inquiry, but the amounts of these deposits must be declared as assets in the SALN, converted to Philippine peso, without need of disclosing details like the existence of the foreign currency accounts, the name of the bank, and account numbers. Furthermore, RA 6713, in requiring that the SALN shall contain information on all other assets, does not distinguish between peso and foreign currencies. When the law does not distinguish, neither should we distinguish. The respondent has consistently misinterpreted all the laws as releasing him from his constitutional duty to disclose his entire assets in his SALN. The respondent never corrected his SALNs to reflect his true net worth. These facts have convinced the Senator Judge of the respondent's intent to avoid his constitutional duty to disclose his true net worth. Simple lang, kung ayaw mong ilahad ang tunay mong yaman, huwag kang pumasok sa gobyerno. Under RA 6713, any violation is sufficient cause for removal or dismissal of an ordinary public employee. Ang patakarang pinapatupad para sa pangkaraniwang empleyado ng gobyerno ay dapat ding ipatupad sa punong maestrado, sapagkat tayong lahat ay pantay-pantay sa ilalim ng batas. Ang batas para kay Juan ay batas din para kay Renato. Therefore, the Senator Judge finds the respondent Chief Justice Renato C. Corona guilty of culpable violation of the Constitution and betrayal of public trust under Article 2 of the Articles of Impeachment.
Honorable Senator Judge Recto.
Just a minute. Let's have a recess for a few minutes.
Okay. So, 14 ang guilty, 3 not guilty, 0 abstention.
Mamaya talakayin natin yan. Manatili po nakatutok dito sa GMA News TV.
Magbabalik po ang The Chief Justice on trial.
Na ng DOH ang ampalaya upang makatulong sa pagkontrol ng diabetes.
Lahat tayo inaasahan ng ating mahal sa buhay, kaya't pag-exercise, kumain ng tama, huwag magpabaya at mag-ampalaya plus araw-araw. Numero 1 sa akin.
Irritated eyes dahil sa usok?
Huwag gusutin! Baka mas ma-irritate ang mata mo. Mag-eye-mo ka!
IMO Red Eyes Formula quickly clears red and irritated eyes.
Ayos, di ba?
IMO Red Eyes Formula clears red eyes fast.
Ang bata-bata mo pa. Magre-retire ka na? Tough choices. Are you ready to make them? Let's make it easy. BPI. Talk to us.
Lahat tayo inaasahan ng ating mahal sa buhay, kaya't pag-exercise, kumain ng tama, huwag magpabaya at mag-ampalaya plus araw-araw.
Ito'y may sangkap na ampalaya, panaba at luyang dilaw.
Mag-ampalaya plus, maaasahan, numero 1 sa akin.
Heto na ang makasaysayang paglilitis, ang hatol, The Chief Justice on Trial. Kapartner ang Ampalaya Plus.
Nagbabalik po ang special coverage ng GMA News TV sa pagbababa ng hatol na impeachment court laban po kay Chief Justice Renato Corona. Balita mo na tayo kay Lia Manyalak.
Bago si Lia, siguro balikan natin ang ating talakayan. Nako, iilan lang ang balanse natin, no? May Recto, Revilla, Soto, Trillanes, Villar, at ang panghuli, ang presiding officer na si Juan Ponce Enrile. Ngayon, kung makaabot tayo ng 16 or 8 before we finish everyone,
Papaliwanag.
Tigil na ba? Hindi, papakinggan na siguro.
Papakinggan pa rin yun, no?
Oo.
So kaya importante yung order ni Sergeant at Arms Balahadya na, di ba yung order, we have to really preserve the order in court.
Abangan pa rin
Hanggang
si
tapos na ang paglilitis.
Senator Enrile, siya huli.
Correct. Gusto niya siyempre marinig
Okay.
siya.
So far, lahat to ng mga narinig nating argumento, tumukoy dun sa empleyado ng korte. Yung interpreter na hindi nakapag-deklara ng kanyang stall, no? Market stall. At
Kilala na siya.
lahat daw dapat pantay-pantay. Tama naman yung ganong paglalarawan po ba para ibigay yung guilty verdict ng isang senator judge?
Oo, nagkataon kasi na ang pinag-uusapan doon silent din.
Tsaka Supreme Court ang nag-decide din doon sa interpreter, ano?
Kasama na ba si Chief Justice nung nag-decide?
Indeed.
Ano yung naging decision niya tungkol sa
Yun na
market,
nga.
sa stall order?
Diba? Na paalis. Nagkataon silent din. Nagkataon member ng judiciary. Kung ang tinatawag nating lowly interpreter, ganun ang standard na hinihingi, di mas lalo na ang Chief Justice, yun yung puntos doon.
So in the same manner, siguro yung mga kapwa justice ni Chief Justice sa Supreme Court na let's say hindi nagdeklara ng kanilang dollar accounts doon sa salin, siguro kinakabahan na sila. Does that mean automatically impeachable na sila?
Ay, kung makita. I mean, not only the justices of the Supreme Court, but everybody in government, no, whether impeachable o hindi, siguro nininervous na.
Din doon sa mga explanation ng mga senator judge, parang pagboto nila ng guilty kay Chief Justice Corona, parang may mga pangako sila ng magandang buhay, no, para sa Pilipinas. So may moral, ano na ba to? Ano tayo? Parang pagbuhay muli ng moralidad pagdating sa political exercises natin.
Palagay ko mayroon, Arnold, lalo na kung pakinggan nila yung tawag ni Chief Justice Corona na i-waive din nila yung
yaman nila.
Confidentiality privilege sa mga bank accounts at sa SALN. Yun nga ang tawag din ni Senator Escudero. At kung gano'n, makikita ng taong bayan kung sino talaga ang may tinatago at kung sino ang malinis.
So ang nakikita na natin, no, 14 na yung guilty, 14. No? Is it too early to call a conviction here?
I think more or less ine-expect na natin kung sino yung mga boboto ng what, no? And to my mind, I think sealed na.
Sealed na, yes.
To my mind.
Because kung acquittal, dapat from recto all the way down to Villar, bumoto sila ng acquittal para makuha nila yung 8, di ba?
Which is difficult, I think, to attain.
And then we're still waiting also for the vote of Enrile, of course.
That's right.
Siyempre, pati explanation niya, yun ang talagang inaabangan natin. And then, so kung lumabas na nga itong conviction, no? Sabi ni Associate Justice Martin Villarama na siyang ponente dapat ng desisyon questioning the impeachment proceedings, sabi niya, gagalangin daw nila ang desisyon ng impeachment court. So, do we take his word for it? Or sinabi lang sa mga reporters, so does it have to be in paper?
Well, I think we should respect Justice Villarama for his statement. Ang nakikita natin, and I've seen this elsewhere, maybe they will just consider this as a moot and academic. So they will not...
By June pa no?
I'm sorry?
Yung schedule yata by June, so...
June 19 pa ata.
So yung tungkol sa petition questioning the jurisdiction.
Yes.
Maybe they will just consider it moot and academic. After all, the decision has been rendered. Para pa, di lalong magkakagulo. At saka pag-iisipan din nila magiging epekto. Kakaroon ng clash
Yes. At saka baka sila mismo ma-impeach kung... I guess they have to be very cautious also dahil baka pagbalingan sila ng galit, no, at maging sila ay ma-impeach dahil nga sa paglabag nila.
Nabanggit nga no ni Senator Escudero, let this be a lesson. Not necessarily in so far as the impeachment rules are concerned or impeachment per se. Pero isang magbubukas signal to everybody na, look, somebody's looking over your shoulder. Okay. Not in those words, pero yun ang epekto.
Naobserbahan ko lang po doon sa mga nag-guilty, no? Parang nakapag-decision sila during the appearance ni Chief Justice Corona, no? Dahil kino-question nila yung manner, no, ng impeachment. kino-question nila yung na-bloated na mga ebidensya, no? Pero nung humarap na siya in person at inadmit niya yung dollar and peso account niya, lahat ng mga senator judge, yun yung pinagbasihan nila in judging ito pong si Chief Justice. Yung mere admission ho ba, hindi ho ba enough o best defense yun ng isang inaakusahan?
Oo. In other words, Igan, admission against interest yun Chief Justice Corona.
Oo.
Kaya kung ano man ang kulang sa ebidensya ng prosecution, parang yung defense mismo ang nag-fill ng gap sa kulang ng ebidensya ng prosecution.
Opo.
Kaya hindi na makapag-complain ng defense ngayon kasi lahat ng mga senador na bumoto for conviction mukhang binasa nila doon sa admissions ni Chief Justice. Kaya medyo...
Parang nawala yung 40 days na nauna, no? Tumutok sila sa 2 araw, no?
Parang naging turning point itong testimony ni Chief Justice. Pakikita natin, hindi lang sa mga bumoto ng guilty, pati yung not guilty, ginamit. Yung iba, pinaniniwalaan si Chief Justice, yung mga nagboto ng not guilty, yung iba, hindi pinaniniwalaan. So, turning point talaga, whether or not for or against ang testimony niya.
Okay, bakibalita muna tayo kay Steve Dailisan. Tingnan natin yung reaction po ng Korte Suprema, yung mga empleyado doon.
Yan ang inaabangan natin.
Steve, ayan, nakamonitor sila dyan. Kamusta yung mga reaction dyan?
Alam mo, Igan, kanina nung nagsimula itong, syempre yung pagsisimula ng pagbibigay ng hatol kay Chief Justice Corona, punong-puno itong lobby na to. Kumbaga, marami rito, nakaupo kanina, mga nakapula. Pero sa mga sandaling ito, unti-unti nang nagsisipag-alisan yung ibang mga court employees, at karamihan nga sa kanila nakasimangot, malungkot, karamihan yung iba nga may na-interview pa tayo kanina na galit daw, yung daw hindi lang daw dismayado yung kanyang paglalarawan sa kanyang nararamdaman, kundi galit dahil dito sa resulta nga ng botohan, although meron pa namang ilang mga senador na boboto pa. Kanina nung nakausap natin si SEA President Jojo Guerrero, ang binabanggit niya sa atin sana raw hanggang sa huli pairalin yung kumbaga yung rule of law, kumbaga yung hindi ibase sa politika, pero ang sinasabi na sa atin mukhang hindi raw yun yung nagiging resulta ng botohan sa ngayon. Ito nga ibang mga court employees dito, yung mga nananatili hanggang sa huli umaasa na ma-acquit pa rin si Chief Justice Corona. Yung mga umalis kanina ay nagpaabot na rin sila ng mensahe kay Chief Justice Corona na naging mabuti naman daw itong leader dito sa Korte Suprema at sana raw ay gumaling ito sa kanyang karamdaman at sana raw ay umigi rin yung lagay ng kanyang pamilya. Igan, kanina banggitin ko rin, habang nagsispeech yung ilang mga senador, habang inilalatag yung kanilang mga boto, partikular na naghiyawan itong mga taga rito, yung mga empleyado dun sa naging speech ni na Senator Joker Arroyo, syempre kanina, kung hiyawan ko yung kay Senator Arroyo, nung nagsalita na itong si Senator Miriam Defensor Santiago, hindi na magkamayaw yung mga nandito. Pero lahat ng yan, nung magsalita naman si Senator Franklin Drilon na talaga namang nabu nitong mga empleyado ng Korte Suprema. Igan.
Steve, sa mga nakakausap ng empleyado dyan sa Korte Suprema, sino ba yung napupusuan nilang kapalit ni Chief Justice Corona kung sakasakali mang magtuloy-tuloy na itong conviction?
Vicky, wala silang nababanggit pero ang sinasabi nila, ang most likely raw, yung most senior, kundi itong si Justice Carpio. Pero ang sinasabi nila, pauubayan nila ito dun sa JBC dahil ito naman ang pipili at magno-nominate para mapili ni Pangulong Ninoy Aquino. Pero sana nga raw, sinasabi nila, wag nang maging paulit-ulit yung ganitong cycle. Ang kinatatakot nga kasi nila, baka mamaya, yung mga hindi pa rin kaalyado ng palasyo ng mga justices, isunod naman sila. Dahil yun nga raw yung mga naririnig nilang banta nitong mga nakaraang buwan. Kaya nga, ang panalangin lang nila, kung sino man daw yung papalit, sana maging karapat dapat din sa pwesto. At nangako naman din kanina nung makausap natin si SEA President Jojo Guerrero na susuportahan daw nila kung sino man yung uupong panibagong Chief Justice.
Okay, so handa sila makatrabaho ang isang bagong Chief Justice kung sakasakali.
Handa naman daw sila, Vicky. Ang sinasabi lang nila sana ay kumbaga maging karapat dapat din yung ipapalit kay Chief Justice Corona dahil naging maganda naman daw yung pamamalakad niya dito nga sa Korte Suprema, Vicky.
Alright.
Steve?
Yes,
Steve. Okay. Kamusta ang trabaho dyan? Shifting ba sila? May mga, nagpapalit sila, hindi naman naka-holiday ang korte ngayon, di ba?
Tama ka dyan, Igan. Walang work stoppage today. Lahat sila pumasok dito. Paramihan nga, yung nagsimulan dumami yung mga tao dito, mga bandang mga 3:30 na. Kasi yung iba, meron sila mga bitbit na mga portable na TV doon sa kanilang mga opisina, doon sila sumubaybay. Pero yung iba, talagang yung mga sumusuporta kay CJ Corona, dito talaga sila umupo sa mismong lobby. Ang sabi lang nila, tuloy yung trabaho ngayon, walang naantalang trabaho ngayon. At magpapatuloy pa rin daw, syempre, yung trabaho nila hanggang bukas, Igan.
Okay.
Alright. Maraming salamat sa iyo, Steve Dailisan.
Darito naman po pahayag kanina sa media ni Lead Prosecutor Representative Neil Tupas. Pakinggan po natin.
Tingin ko walang celebration na mangyayari, no? Because para sa akin, it was a very painful process, no? Like ako, ang dami kong dinaanan na masama rin, di ba? Like mga pambabastos, no? Na hanggang last minute kanina, humirit pa. So, tingin ko wala maging celebration dito, but it's really the people who will celebrate here in the long run.
Sir, ano po yung naramdaman nyo kanina nung nag-comment o nagsalita ng ganun si Senator Santiago?
Doon kanina, parang, this is a solemn moment for all of us. Kanina ang sama ng pakiramdam ko, di ba? Kasi hanggang sa kahuli-hulihan ba naman, may mga ilan pa na hindi magiging statesman-like or stateswoman-like yung mga sasabihin sa prosecution. It was a big disappointment for us, but we accept it because we accept naman anything. The objective here, the prosecution, to get the things done, and I think we're on our way to accomplish that. Hintayin natin yung ilan pang hindi nakakaboto, 14-3, 17, so meron pang 6. At we are confident dahil sa kanina sinasabi yung mga ebidensya, and we're confident. Hindi lang namin naasahan na mukhang talagang lalagpas, baka umabot pa ng 20 votes. No?
Hawon po kanina si Senator Santiago sa inyo na parang sino ba dito yung malinis, patunayan at kung bibigyan daw siya ng pagkakataon na magkaroon ng isa pang buhay, iimbestigahan din daw po niya.
Mahirap rin kasi yung magsalita Dapat gawin niya na lang. Gawin niya kung like kami dito, hindi naman kami nagmamalinis. Ang amin dito talagang genuine ang puso namin. Ako ano ba magigain namin dito? Pero ang magigain namin dito, yung fulfillment namin na nakatulong kami sa aming bayan. Ito parang just a little contribution to our nation. Ito lang yung sa amin That's why I'll tell the prosecution later, no celebration. No celebration. Naging masakit ito sa lahat. And I think that celebration will come in the
Okay, si Congressman Tupas.
Alright. Balik naman tayo sa ating diskusyon.
Dean Pacifico Agabin at Professor Rowena Darwin Morales.
Okay, ang gusto ko malaman ngayon, ano ba ang consideration in choosing a next Chief Justice? Is it seniority? How do we start the process?
Well, it's not necessarily seniority.
Pwede nga outside ng Supreme Court, di ba?
Oh, yes. The President can choose even from outside the Supreme Court.
Pero di ba may shortlist na binibigay sa kanya ang Judicial and Bar Council and then he chooses from there?
Oo, pero kung manggaling sa labas yung Chief Justice, isusumite rin sa JBC.
Dapat i-absorb na rin yung resolution na hindi sila pwedeng isa publiko yung kanilang salin. Di ba? Bilang unang hakbang nung... teka muna. Ayan na ulit tayo. Senator Enrile po, balikan natin ang impeachment proceedings.
Thank you, Mr. President. I base my decision on the facts presented in this court and not on opinions aired outside of it, on testimonies of witnesses and not on theories of wags, on the arguments of lawyers and not on the analysis of their spokesmen, on submitted evidence and not on anonymous leaks, and above all, on the figures in official documents and not the numbers on the recent polls. Because as a judge, my duty is to choose what is right and not what is popular. Having expressed the foundation of my decision, let me put forward my observations on this trial. First, in an impeachment complaint, length is not strength. Better for an indictment to be short but substantial than one that is long in allegations but short in proof. Second, haste makes waste. The reason why the trial simmered in the Senate is because the articles were served half-cooked instead of well done. Third, the way evidence was produced left a bad taste in the mouth. Mr. President, let me now explain my vote. There is no such thing as a SAL-N so statistically perfect that it is precise to the last decimal point. If a government employee is asked to catalog what he owes and what he owns, some information may fall into the crack, not as an act of deliberate concealment, but as an unwitting omission done in good faith. So this boils down to the degree of the unintentional miscalculation, and logic dictates that we accept the slight inaccuracies, because if we leave no room for those, then believe me, no government official will be left behind his desk. In the case of the Chief Justice's SAL-N, the undeclared assets are so huge, 50 times more than what he declared in cash. 2.4 million in US dollar deposits, 80 million in peso deposits, that they cannot be brushed aside as innocent exclusions. The very same Constitution that he had sworn to obey and uphold makes it mandatory for a public officer like him to submit a true declaration under oath of his assets, liabilities, and net worth. Mr. Corona knows this because in cases brought to the Supreme Court, he had punished his fellow government workers for failing to disclose far lesser amounts. He should have declared the above. Thus, I vote guilty on Article 2. Mr. President, in a few hours, we will be pulling the plug on this afternoon's political telenovela. With a sigh of relief, let's go back to our regular programming where hard, unheralded work is done away from the camera lights. The end of the trial doesn't call for celebration. It calls for getting our bearings back and setting our priorities right again. 1 in 5 people who watch this trial on TV occasionally go hungry. 1 in 3 in the labor force had all the time to watch because they had no work. 5 in 10 people who followed this trial rated themselves poor. 80% do not even have a bank account or savings. So if we think what we have done here is Herculean, then we stand indicted for being clueless of what our people want and ignorant of our true potential. It is easy to impeach one man. What is hard is to impeach hunger, to impeach joblessness, and to impeach poverty. Thank you, Mr. President.
The Honorable Senator Judge Revilla.
Thank you.
Thank you, Mr. President. Mga kababayan, I stand here today in a historic moment when we render judgment not to an ordinary citizen, but to the highest official of our co-equal branch in government, the Chief Justice of the Supreme Court of the Philippines. As the late President Theodore Roosevelt said, a nation must be judged in part by the character of its public men, not merely by their abilities, but their ideals and the measure in which they realize these ideals, by their attitude in real life, and much more by their attitude in public life, both as regards their conception of their duties toward their country and their conception of their duty embodied in its government towards its own people. I have heard all the arguments, considered all pieces of evidence of the prosecution and the defense, and heard directly from the Honorable Chief Justice himself. As much as the Chief Justice of the Republic of the Philippines expects and demands and is worthy of all the respect and considerations due to his office and to his person, he, in return, has the responsibility to be the epitome of a public servant with the highest ethical standards. Bilang pinakamataas na mahistrado ng bansang ito, ang kanyang panunungkulan ay dapat walang bahid kahit katiting dahil sa mandato ng kanyang katungkulan at kahalagahan ng kanyang posisyon. In the end, I arrive with the conclusion that through his own direct admission, the Chief Justice failed to properly disclose all of his assets in his SALN. This, therefore, has necessary consequences that attach to the position he holds in trust. I prayed hard for divine providence and guidance in this one great decision of my life, Mr. President. Napakahirap man, alang-alang sa pagkakaisa at paghilom ng ating bayan, alang-alang sa pagpapatibay ng mga institusyon ng ating pamahalaan, alang-alang sa mga darating pang henerasyon at ang ating kinabukasan, I find Chief Justice Renato C. Corona guilty.
The Honorable Senator Judge Soto.
Mr. President, Article 2 of the Articles of Impeachment states that the respondent committed culpable violation of the Constitution and or betrayed the public trust when he failed to disclose to the public his statements of assets and liabilities and net worth. I have come across Supreme Court decisions whereby lower court judges had been dismissed and deprived of all their benefits for simple infractions of law or missteps in judicial conduct. Question: should the same strict measures ought to be applied to the members of the Supreme Court? The answer depends on who you ask. So I put that aside. Let's put that aside. After 43 days, this trial has been heard by the people. The Constitution mandates that the Senate try impeachment cases. Ang taong bayan ay naghahalal ng mga senador mula sa iba't ibang propesyon at estado ng lipunan upang sila'y katawanin at bumigkas ng kanilang saloobin. Ang tunay na hukom sa paglilitis na ito ay ang taong bayan. Nadinig nila ang dalawang panig. Tulad namin, hindi lahat sila abogado. Ngunit ang kapangyarihan ng demokrasya ay nasa kanilang mga kamay. In my conscience, Mr. President, I have heard their decision, and for them, I vote guilty.
The Honorable Senator Judge Trillanes.
Thank you, Mr. President. My verdict is guilty, and this is my explanation. Based on the evidence and admissions, Chief Justice Renato Corona had at least 80 million pesos and $2.4 million, which he did not disclose in his SALN. As an explanation, he said that he was bound by the absolute confidentiality clause of the Foreign Currency Deposit Law. As to the peso deposits, the Chief Justice claimed that they were commingled with other funds that were not his, and therefore, he could not disclose them. However, Article 11, Section 17 of the Constitution is very clear in its language. A public officer or employee shall, upon assumption of office and as often thereafter as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. To interpret the confidentiality clause of RA 6426 as a prescription to the disclosure of dollar deposits is erroneous, self-serving, and an afterthought. As to the claim that the peso deposits were commingled, the AMLAC documents, which showed a steady stream of deposits worth millions of pesos to the accounts of the Chief Justice, were given more weight and credence. Now, as to the matter of public policy, it is in the interest of the country to convict Chief Justice Renato Corona. A conviction signifies that transparency and accountability as principles in governance take precedence over legal technicalities. This effectively takes away any refuge for the corrupt public official. Moreover, the claim of commingled funds and the confidentiality of dollar deposits will never be accepted as alibis. A conviction also signifies that our system of checks and balances is working well, and that impeachment can now be effectively used as a tool of the state to make high government officials accountable for their actions. From now on, no one is untouchable. Lastly, a conviction signifies that we have considerably raised the standards for a Chief Justice of our Supreme Court. He must not only possess vast legal knowledge and wisdom necessary to interpret the law according to its spirit and intent, but more importantly, he must have unquestionable moral integrity and strength of character to render him impervious to corruption and political pressure as he administers justice for our country and people. Thank you.
Honorable Senator Judge Villar.
Mr. President, my esteemed colleagues, ladies and gentlemen, my vote is for the conviction of the Chief Justice. Let me explain. Nahirapan po ako dito sa aking desisyon na ito. Pinapanood ko pong mabuti ang mga hearings natin. Nalulungkot po ako sa maraming mga bagay na nangyayari noon. Dito sa properties po, nababasa natin 45. Hindi ko po binilang yan. 5 lamang aking binilang. Doon sa 82 accounts, hindi ko rin po binilang yon, 4 lamang po ang aking binilang. Doon sa $12 million, hindi ko rin po matanggap yon. Binilang ko lamang ay 2.4. Ang desisyon ko po ay base sa kanyang inamin po na kanyang pag-aari. Ito po ay yung $2.4 million at yung 80 million pesos. Dito po, medyo ako nahirapan dahil alam po naman natin na ang posisyon po ng pangunahing maestrado ng ating Korte Suprema ay siyang pinakamataas. ay siya mayroong pinakamataas na batayan ng integridad. Nabalitaan ko po yung isang empleyado na nahatulan dahil hindi nagdeklara ng kanyang tindahan. Nahirapan po ako dyan. Bagamat mabigat po sa aking kalooban, talagang naniniwala kasi ako na dapat ideklara ang FCDO account. Sapagkat yun ay pag-aari pa rin. Nung dumating po si Chief Justice Corona, ako po ay naawa sa kanya. Dahilan sa noong pa lamang sa mga hearings, talagang naawa na po ako kay CJ Corona. Dahilan siya talagang pagbukas ko ng dyaryo, headline na siya. Hindi pa man po siya guilty, ay parang meron ng conclusion ang ating pong mga media at ang mga tao. Kaya naglabasan na po yung kanyang mga properties, 82 accounts, $12 million. Subalit nung mapatunayan naman po na hindi ganun kadami ay mga nasa page 14 na lamang. Naalala ko rin po kasi na nangyari din sa akin po yan. Nung ako po tumakbong pagkapangulo, ay katakot-takot na kasinungalingan din ang aking inabot. Katakot-takot na bintang. Nariyang meron daw akong bahay sa Utah na pagkalaki-laki mansyon, hindi pa ako nakakarating sa Utah. Tanggi ako ng tanggi, subalit wala naman nakikinig. Nandong hindi daw ako mahirap. Ako ba'y magtitinda ng hipon kung hindi ako mahirap? Kung ako mayaman? Nililiwanag ko po na ako'y mahirap at tingnan po ninyo buhay namin sa tundo. Subalit, napaniwala po marami sa ating mga mamamayan. Ito po naman yung sinasabi ko dahil hindi wala po ako sama ng loob kanino man. Aalala ko lamang po, tuwitititigan ko si CJ Corona. Nandiyan na rin po yung C5, Andang Hari Road, na ngayon po'y ginagamit ng milyon-milyong mga Pilipino na nakikinabang po sila. Hindi po ako nakinabang dyan. Isinama ko pa lahat ng membro ng media dyan sa kali na yan. Itinuro ko po lahat yan. Hindi po ako nakinabang dyan. Subalit, ito po yung nagamit na issue. Villaroyo, daw ako. Pinakamalaking kasinungalingan yan. Alam po na makasama natin sa House na bumoto ang aking asawa laban kay GMA sa impeachment. Nagkampanya ang Nationalista Party para ma-impeach si GMA, Pangulong Arroyo. Alam po naman natin na ako ang namuno ng investigasyon ng Weteng laban sa Pangulong Arroyo. Alam natin na Nationalista Party member ang namuno ng investigasyon ng ZTE, si Alan Cayetano. Alam natin na Nationalista Party member ang namuno ng pag-imbestiga sa Hello Garci. Yan pong mga miyembro na yan, kinusulta ko, sabi ko, go ahead. Napakaraming beses ko pong kinwestiyon ang Pangulong Arroyo sa Supreme Court. Subalit, sa kabila niyan, sinabing ako'y Villaroyo at anuman tanggi ang gawin ko. Alam naman na may kandidato po noon si Pangulong Arroyo na iba. Wala pong mangyari. Dahilan po, may konklusyon na ang media. Inuulit ko po na wala na ako sama ng loob, nakalimutan ko na po yan. Tangat nga lamang at naalala ko, tuwing maalala ko rin si CJ Corona ng huling araw. Marami pa ho yan at ayoko na lamang banggitin ngayon, hindi siguro po ito ang tamang panahon. Dahil unang-una nakalimutan ko na nga po yung mga bagay na yan. Kaya lamang dapat din po tayo mag-ingat. Yung pagwasak po ng pangalan ng isang tao, isang bagay na dahan-dahan po tayo. Hindi naman po kailangan yan. Dito naman, ang issue ay simple lamang. Ang issue po dito ay kung dapat idineklara ang yung sa SALN ang dollar deposits. Sa dami-dami po na sinabi, doon lamang nalimita ang issue. At dito po kami halos lahat gumawa ng desisyon sapagkat hindi naman po namin matanggap na hindi kailangang ideklara ang FCDU account. Bagamat ako po'y bumoto ng guilty, naniniwala po ako mabuting tao si CJ Corona. Ito ay isang error in judgment. At inuulit ko po na napakataas po ng antas ng integridad na kailangan sa posisyon ng pangunahing maestrado ng ating pong Korte Suprema. Pabayaan niyo pong bigay ko rin ang obserbasyon ko sa mga nangyari noon. Ako'y nalulungkot din na meron tayo, at sana wag na po mangyari sa mga darating na panahon ng illegal na pagkuha ng mga ebidensya ay parang normal o binabaliwala natin. Napakahalaga po niyan sa ating sistema ng hustisya. Napakahalaga ng isang ebidensya na hindi legal ang pagkuha ay hindi pwedeng tanggapin. Sana po, yung mga hindi na maulit, yung mga little lady, yung mga mailbox, mga Mr. Anonymous, yan po, sabi nga ni Congressman Pariñas, mga palusot. Huwag na po sana maulit dyan sa mga darating na panahon. At huwag na rin po sana maulit yung walang pakundangan na paggamit ng mga ahensya ng gobyerno. Mahalaga din po na mahalin natin ang kalayaan po ng ating mga institusyon. Yan po ay magpapalakas ng ating demokrasya. Mahalaga po sa akin ang mga bagay na yan at inuulit ko po, naniniwala ko, mabuting tao si CJ Corona, subalit dito po sa issue ng FCDU account, nagkamali po siya rito. Naniniwala po ako na dapat pantay-pantay ang implementasyon ng batas na ito. Mayaman man o mahirap, miyembro man ng Korte Suprema o pangkaraniwang mamamayan. Kaya po ako ay bumoto ng guilty.
The Honorable Presiding Officer, the Senate President.
Thank you. Magandang hapon po sa inyo lahat. Unang-una, gusto kong pasalamatan ang aking mga kasama sa Senado na ngayon ay ginagampanan ang katungkulang bilang hukom dito sa paglilitis na ito sa kataas-taasang mahistrado ng ating kataas-taasang hukuman sa ating bansa na siya ang tinatawag na guardian ng ating saligang batas at ang kalayaan ng ating mamamayang Pilipino. Gusto ko rin pasalamatan ang mga abogado ng dalawang panig nandito ngayon, the prosecution panel as well as the defense panel for their untiring effort in participating in ferreting out the truth in this trial and in order to arrive at a just resolution of the case before us. In the entire course of this impeachment trial, I've faced many difficult challenges to my own and the court's collective wisdom. our sense of justice and fairness, the delicate balancing act we must perform to ensure that we do not stray from the strictures of the Constitution, the laws, and our rules. This trial began and unfolded against the backdrop of a highly charged and emotional atmosphere, acrimonious debates in and out of the confines of this court, and a deep political fissure which threatened the stability of our democratic institutions. But the impact of the many events that transpired since December 12 last year to this very day, taken together, cannot compare to the sense of heaviness that I feel at this very moment. The culmination of this national drama is at hand, and the time has come for me to render judgment on the person before whom I took my oath of office as a senator of this republic, no less than the Chief Justice of the Supreme Court, Renato C. Corona. The respondent Chief Justice and his family understandably feel deeply hurt, pained, and aggrieved. As a lawyer, I must confess that I was personally frustrated, really frustrated, by the loose and hasty crafting and preparation that characterized the presentation of the charges contained in the articles of impeachment. It seems that the case was being built up only after the charges were actually filed. The repeated recourse to this court's compulsory processes to obtain evidence which normally should have formed the factual basis of the charges in the first place further burdened and at times taxed the patience of this court. We have witnessed with disdain the indiscriminate, deliberate, and illegal machinations of some parties who have been less than forthright with this court and its members in presenting dubiously procured and misleading documents which were spread to the media, obviously to influence these courts and the public's opinion. The letter of this administration of the Land Registration Authority, which contained as an attachment a list of 45 properties supposedly owned by the respondent Chief Justice, was fed to the media even before we could begin the actual trial of the case. Even before the Honorable Ombudsman, Conchita Carpio Morales, was called to testify before this court, her letter to the Chief Justice requiring him to explain in 72 hours an alleged aggregate amount of US $10 million in several dollar accounts was leaked to the media right before the resumption of this trial last May 7. We have sternly cautioned against unethical and unprofessional conduct the penchant to engage in trial by publicity, to use the media to disseminate and advance so-called information or evidence, to provoke and disrespect this court and its members, and to irresponsibly hurl disparaging insinuations and accusations. We have tried to impress upon everyone who may be similarly motivated and inclined to test our will that this court means serious business and would not succumb to or allow such underhanded tactics and gimmickry to deter this court from our task. Prudence and justice dictate that in determining the guilt or innocence of the Chief Justice, we must try our best to confine ourselves to the pieces of testimonial and documentary evidence that have been presented to this court, to pass upon their relevance and to measure and weigh their value in the light of the charges before us. After all the accusations leveled against the Chief Justice, 8 charges in all comprising the articles of impeachment, the prosecution chose to present evidence only on 3 articles, namely Article Roman number 2, Roman numeral number 2, Roman numeral number 3, and Roman numeral number 7, and then abruptly rested its case. I've always believed that of these three, the case for the prosecution and the defense will rise or fall on Article 2, which is now the subject of our vote. This court, at one point, had extensive discussions and differences of opinion, to be sure, regarding the charge contained in paragraph 2.4 of Article 2, that the Chief Justice was, and I quote, suspected and accused of having accumulated ill-gotten wealth, acquiring assets of high values, and keeping bank accounts with huge deposits. Close quote. We ruled to disallow the introduction of evidence in support of paragraph 2.4, which to this day I strongly maintain, as I'm sure my colleagues in this court strongly maintain, was an invalid charge, it being based on mere suspicion, on so-called reports, rather than on factual allegations. The defense and the Chief Justice himself, unhappily, somehow revived this issue of the nature of his assets by introducing evidence to prove that his income and assets were legitimate, and by testimony to show how he and his wife had saved and invested these savings in foreign currency over so many decades. At this moment, I wish to reiterate for the record that the Chief Justice does not stand accused of having amassed any legal wealth before this impeachment court. Paragraph 2.2 of Article Roman numeral 2 of the Articles of Impeachment accuses the respondent, Chief Justice, of failing to disclose to the public his statement of assets, liabilities, and net worth as required by the Constitution. I submit that the Chief Justice had justifiable and legal grounds to rely on the Supreme Court's procedural and policy guidelines governing such disclosure as embodied in a resolution promulgated way back in 1989 when the respondent was not yet a member of the Supreme Court. Under the said guidelines, the Clerk of Court of the Supreme Court, who is the repository of the SAL-Ns submitted by all the members of that High Court, may furnish copies of the SAL-Ns in his or her custody to any person upon request and upon showing that there is a legitimate reason for the same. The Constitution, in Article 11, Section 17, states that, and I quote, in the case of the President, the Vice President, the members of the Supreme Court, the constitutional commissions, and other constitutional offices, and offices of the armed forces with general or flag rank, the declaration shall be disclosed to the public in the manner provided by law. RA 6713, known as the Code of Conduct and Ethical Standard for Public Officials and Employees, recognizes the public's right to information on the assets, liabilities, and net worth, financial and business interests of public servants, but it likewise declares it unlawful for any person, and I would like to quote the provision, to obtain or use the same for purposes contrary to morals or public policy, or for any commercial purpose other than by news and communications media for dissemination to the general public. Close quotation. Period. Whether the said guidelines violate the letter and spirit of Republic Act 6713 and the principle of public accountability is not, I repeat, is not for this court to pass upon. I grant that the Chief Justice believe in good faith that after periodically filing his sworn statement of assets, liabilities, and net worth, the guidelines issued by the Supreme Court were sufficient to allow the Clerk of Court to comply with the Constitution and the law. We cannot ignore the fact that the failure or refusal, particularly of public officials in high government positions, to provide the public or the media with copies of the SAL-Ns continues to be a raging issue to this day. In fact, some, if not most, of the members of the prosecution panel itself, the members of the Supreme Court, members of the Congress, and other high officials of the government have been challenged by media organizations and others to make their SAL-Ns available to the public and to the media. Paragraph 2.3 of Article Roman numeral number 2 further accuses the respondent Chief Justice, based on reports of not including some properties in his declaration of his assets, liabilities, and net worth, in violation of the Anti-Graft and Corrupt Practices Act. The prosecution, based on the list it procured from the Land Registration Authority, claims that the Chief Justice owned and failed to fully disclose in his SAL-N 45 real estate assets. Based on the evidence, I'm convinced that the defense has presented credible evidence to refute this charge and to explain the exclusion in the respondent Chief Justice's SAL-Ns of certain properties which have either been sold or legally transferred, properties which are actually owned by his children and or third parties, and properties which were never owned by the respondent Chief Justice in the first place. I am likewise convinced that the defense has sufficiently established that there was no ill intention on the part of the respondent Chief Justice to understate or misrepresent the value of his real properties. Proceeding now to the most significant charge involving the non-disclosure of the respondent Chief Justice's cash assets. The Ombudsman, at the instance of the defense, testified with a presentation of a report from the Anti-Money Laundering Council, AMLC, showing 82 bank accounts allegedly belonging to the respondent. She further testified that based on her analysis of the report, aided by the Commission on Audit, the Chief Justice had cash assets in the examined bank accounts or of anywhere from US $10 million to US $12 million. Even if we grant the existence of these 82 accounts, the amount of deposits corresponding to each of these could not just easily, fairly, or logically be summed up to arrive at exactly how much cash assets or deposits in actuality and totality, and in totality, the respondent Chief Justice had or has at any given point of time. Hence, the Ombudsman's reference to the transactional balance of about US $12 million should not mislead this court in its appreciation of the facts. Regrettably, both the prosecution and the defense panels decided not to present the concerned bank officers or the AMRC to ascertain the veracity of the data allegedly provided by the AMLC to the Office of the Ombudsman, despite the respondent's submissions to this court of a written waiver to cause the opening of all his bank accounts. Laudable as this belated act on the part of the respondent Chief Justice may be, it would have served him better if he had just presented bank instruments, documents, as evidence to either confirm or refute the documents showing his bank transactions as presented by the Ombudsman. It has not escaped this presiding officer that initially, last May 22nd to be exact, before he walked out of this hall, of this court, the Chief Justice signed the said waiver in open court, but made the release of the same conditional. That is, after all the 188 signatories to the articles of impeachment and Senator Judge Franklin Drilon have signed a similar waiver. It was only during their hearing last May 25 that the Chief Justice decided finally to submit a waiver to this court without any preconditions. Moreover, even as the Chief Justice had full access to his own bank accounts and all the opportunity to introduce evidence to disprove the data, findings, and analysis presented by the Ombudsman or the report of the AMRC, the defense did not introduce any such evidence. As it is, the impeachment court could only rely on the documents supplied by the Ombudsman, which show the respondents' bank transactions, but which do not show the actual bank balances of respondents' bank accounts. Instead, the defense presented the Chief Justice himself as its last witness and pleaded for the court's permission to allow the respondent Chief Justice to deliver an opening statement. This court, out of courtesy to the Chief Justice, as the highest magistrate of the land, decided to extend that courtesy to him, its understanding, and to exercise utmost liberality in granting the request for him to speak before us. The long narration, where the Chief Justice touched on a wide range of issues, assertions of facts, accusations, opinions, and personal sentiments, which the respondent said he found necessary to narrate in order to clear his and his family's name, was later adopted by the defense as the direct testimony of the respondent Chief Justice. The prosecution, on the other hand, waived its rights to cross-examine the Chief Justice, provided the defense would not conduct any further direct examination. Nevertheless, the respondent Chief Justice testified and admitted, in answer to questions from a member of this court, that he had around 80 million pesos in 3 peso accounts and US $2.4 million in 4 US dollar accounts, but that he had purposely not declared these assets for 2 reasons. One, that his peso accounts represented commingled funds. And 2, that he was not required to report or declare his foreign currency deposits in his SALN because they were, according to him, absolutely confidential under RA 6426. Ladies and gentlemen of this court, at aking mga kababayan, I disagree on both counts. If indeed any of the respondents' cash deposits were commingled, with the funds belonging to other parties such as the Basagidote Enterprise Incorporated or his children, the respondent was still duty-bound under our laws to declare these deposits in the SALN, they being admittedly under his name by his own very declaration. The evidence is devoid of any indication that the Chief Justice was holding these funds in trust for or that they were actually beneficially owned by anyone other than himself or his wife. Assuming that any part of such deposits in truth belong to third parties, the respondent could have indicated such third-party funds as corresponding liabilities in his SALN that would have reflected his true, real, and real net worth. With all due respect, I believe that the respondent Chief Justice's reliance on the absolute confidentiality accorded to foreign currency deposits under Section 8 of Republic Act Number 6426 is grossly misplaced. The Constitution, in Article 11, Section 17 provides that, and I would like to quote it, a public officer or employee shall, upon assumption of office, and as often as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. The oath required him to tell the truth and nothing but the truth. So help him God. Are we now to say that this constitutional command, mandatory as it is limited to public officials, assets, or deposits in local currency? If so, would we not be saying, in effect, that the Constitution allows something less than a full, honest, and complete disclosure under the first sentence of Section 17 of Article 11? It bears noting that the prescribed form of the SALN quite simply requires public officers and employees to declare their assets, real and personal, the latter to include cash and bank deposits, bonds, and others. It does not require the public officer or employee to indicate whether or not he or she has foreign currency notes or deposits. Neither does it require details such as account numbers, account names, bank identities, nor any branch addresses. All that it requires is a declaration under oath of the total amount of funds deposited in any bank account or accounts maintained by the public official or employee concerned. Surely, the Chief Justice knows the equivalent value in local currency of his foreign currency deposits to be able to declare the same as part of his assets, especially since the aggregate amount of these foreign currency deposits by his own account under oath amounts to $2.4 million. The non-disclosure of these deposits in both local and foreign currency would naturally result in a corresponding distortion of the Chief Justice's real net worth. Consistent with the position taken by this court in the case filed by the Philippine Savings Bank before the Supreme Court last February, pursuant to which the Supreme Court issued a temporary restraining order, I maintain that the constitutional principle of public accountability under Article 11 of the Constitution overrides the absolute confidentiality of foreign currency deposits. The provision of RA 6426 cannot be interpreted as an exception to the unequivocal command and tenor of Article 11, Section 17 of the 1987 Constitution. And I regret that the highest magistrate of the land, no less, would think otherwise. Section 8 of RA 6426 provides that, except with the written permission of the depositor, I would repeat, except with the written permission of the depositor, and I quote, in no instance shall foreign currency deposits be examined, inquired, or looked into by any person, government, official, bureau, or office, whether judicial or administrative or legislative, or any other entity, whether public or private. Any other interpretation of this provision would be unwarranted, and the term any person would not include the depositor. The so-called conflict of laws between RA number 6713 and 6426 is more illusory than real to me. Section 8 of RA number 6426 merely prohibits the examination, inquiry, or looking into a foreign currency deposit account by an entity or person other than the depositor himself, because that depositor knows his deposit and he can reveal it if he wants to without any penalty or punitive sanction against him, unlike others who would reveal it. But there is nothing in RA number 6426 which prohibits the depositor from making a declaration on his own of such foreign currency funds, especially in this case where the Constitution mandates the depositor, who is a public officer, to declare under the Constitution itself all assets owned by him or his family under oath. Some have raised the question, why should the Chief Justice be held accountable for an offense which many, if not most others in government are guilty of? Perhaps even more guilty than he is. They say that hardly anyone declares his true net worth anyway. Here lies what many have posited as a moral dilemma. I believe it is our duty to resolve this dilemma in favor of upholding the law and sound public policy in this country. If we were to agree with the respondent Chief Justice of the Supreme Court that he was correct in not disclosing the value of his foreign currency deposits because they're absolutely confidential? Can we ever expect any SALN to be filed by public officials, no matter how high and no matter how low, from here on to be more accurate and true than they are today? I don't think so. I am not oblivious to the possible political repercussions of the final verdict we are called upon to render today. I am deeply concerned that the people may just so easily ignore, may forget, if not completely miss out, the hard lessons we all must learn from this episode, instead of grow and mature as citizens of a democratic nation. Those whose intentions and motivations may be farthest from the lofty ideals of truth and justice are wont to feast upon this man's downfall should this court render a guilty verdict, as I think it would. I am quite equally aware of the tremendous pressures weighing heavily upon each and all of the members of this court as we had to come to a decision on this case, one way or the other. But to render a just verdict according to my best lights and my own conscience is a sacred duty that I've taken on myself, that I have sworn to perform. As one who has been through many personal upheavals through all my 88 years, I too have been judged, often unfairly and harshly. But I have constantly held that those who face the judgment of imperfect and fallible mortals like us have recourse to the judgment of history and ultimately of God. And so, with full trust that the Almighty will see us through the aftermath of this chapter in our nation's history, I vote to hold the Chief Justice of the Supreme Court, Renato C. Corona, guilty as charged under Article numeral 2, paragraph 2.3, and that his deliberate act of excluding substantial assets from his sworn statement of assets, liabilities, and net worth constitutes, in my humble view, as a member of this court, a culpable violation of the Constitution of the Republic of the Philippines. Thank you.
Mr. President, may we have the summary of the votes?
On Article 2, on Article 2, 20 senators find the Chief Justice of the Supreme Court, Renato C. Corona, guilty as charged. And 3 senators not guilty. With at least 2/3 of all the members of the Senate having pronounced the respondent guilty, the chair, pursuant to Rule 21 of the Rules of Procedure on Impeachment Trials, directs judgment to be entered in accordance with the judgment of the Senate as follows. The Senate, sitting as an impeachment court, having tried Renato C. Corona, Chief Justice of the Supreme Court, upon 3 articles of impeachment charged against him by the House of Representatives, by a guilty vote of 20 senators, representing at least 2/3 of all the members of the Senate, has found him guilty of the charge under Article Roman number 2, Roman numeral 2, of the said articles of impeachment. Now, therefore, be it adjudged, that Renato C. Corona be, and is hereby convicted of the charge against him in Article Roman numeral 2 of the Articles of Impeachment, so ordered. The Secretary, as clerk of the impeachment court, is directed to provide a certified copy of the judgment to the respondent and his counsel, the Speaker of the House of Representatives, the Supreme Court and Bank, the Judicial and Bar Council, and the President of the Republic of the Philippines. So ordered. Majority Floor Leader.
Mr. President. Yes, Mr. President, in view of the judgment against the respondent, I move that the vote on Articles 3 and 7 be dispensed with.
Is there any objection? Hearing none, the Chair hears none. No, the Chair hears none. The motion is approved.
Mr. President, I move that the presiding officer be authorized to approve the journal of today's proceedings.
Is there any objection? Hearing none, the motion is approved.
Mr. President,
the Majority Floor Leader.
I move that the Senate authorize the printing and distribution of copies of the record and journal of the Senate sitting as an impeachment court under the direction of the Secretary of the Senate.
Is there any objection? Hearing none, the motion is approved. Majority Floor Leader.
Mr. President, may we ask the Sergeant at Arms to make an announcement?
The Sergeant at Arms is directed to make the announcement.
Please all rise. All persons are commanded to remain in their places until the Senate President and the Senators have left the session hall.
Mr. President.
Majority Floor Leader.
Thank you, Mr. President. The impeachment trial of Chief Justice Renato C. Corona having been concluded and judgment rendered by the Senate accordingly, I move that we terminate case number 0022011 and that the Senate sitting as an impeachment court adjourn sine die.
Is there any objection? Chair hears none.
Mr. President.
Yes.
Before the adjournment.
Yes.
Senator Angara wishes to.
The gentleman from Aurora is recognized.
I withdraw the request, Mr. President.
Right.
I continue with the motion. You call for the previous question.
Is there any objection? The Chair hears none. The Senate, having fulfilled its duty under the Constitution to try and decide this impeachment case, case number 002-2011, against the Chief Justice of the Supreme Court, Renato C. Corona, is hereby terminated, and the Senate sitting as an impeachment court adjourned sine die.
Bumoto na po at binaba ng hatol ng Senate Impeachment Court. Guilty si Chief Justice Renato Corona sa Article 2 ng impeachment case na ito. 20 senador ang nagsabing siya ay guilty.
Tatlo naman ang bumotong not guilty si Corona. 2/3 ng impeachment court o katumbas ng 16 votes ang kailangan para makonvict ang punong maestrado sa kahit isa lang sa 3 articles of impeachment.
At makibalita tayo kay Lia Manyalak del Castillo mula sa The Medical City. Tignan natin ang reaksyon ng kampo po ni Chief Justice Corona. Lia?
Igan, Vicky, tikom pa rin yung bibig ng pamilya Corona. Wala pang nagbibigay ng opisyal na reaksyon mula sa kanyang pamilya matapos nga itong naging paghatol ng Senate Impeachment Court kung saan guilty nga ang naging desisyon nila dito sa kaso ni Chief Justice Corona. Ayon dito kay Court Administrator Midas Marquez na naririto rin ngayon sa ospital at kasama ng pamilya ay malabo raw na magbigay ngayon ng pahayag yung pamilya Corona. Si Court Administrator Marquez naman daw ay naghahanda na ng posibleng statement on behalf of the family. Pero Igan, nalaman natin kanina, nakaakyat tayo sandali doon sa 15th floor kung saan naroon si Chief Justice Corona. At rinig natin mula doon sa hallway, no, malakas yung volume ng kanilang telebisyon at nanonood yung kanyang buong pamilya ng ginawang botohan ng mga senator judges. Mahigpit ang seguridad doon sa floor na yon ng ospital at maraming mga gwardya both ng ospital at ng Supreme Court ang palakad-lakad doon para magbantay nga na walang makalapit sa kwarto ng Chief Justice. Igan.
May balika ba emotional yung pamilya sa loob ng kanyang hospital room?
Meron tayong isang source na kasama ng pamilya. Ayon sa kanya, hindi naman daw naging emotional. Pero syempre, unconfirmed pa yan hanggat hindi pa nga nagbibigay ng official na pahayag itong si Court Administrator Marquez na nakasama ng pamilya kanina.
Sino-sino ang nandun kasama niya bukod sa kanyang immediate family at si spokesperson Midas Marquez?
Nakita rin natin doon, Vicky, no, yung ilan sa staff ng Supreme Court PIO. At ang ina-expect lang natin na kasama niya doon ay yung kanyang buong immediate family, yung kanyang mga apo, si Court Administrator Marquez, at yung kanyang mga tauhan, no, yung mga staff niya dito sa Korte Suprema. Vicky?
Ano naman, Lia, ang atmosphere dyan sa Medical City? Sa pagkakaalam ko, maging ang mga doktor, ang mga nurse ay nagmo-monitor sa impeachment trial.
Actually, bulag tayo yung sa activities sa loob dahil napakahigpit talaga ng ospital. At yung media nga ay limited lamang dito sa kabilang side lamang ng kalsada.
Lia, teka lang ha. Punta lang namin si Joseph Morin sa Senado. Nandun siya sa mismong floor.
There's no reason not to recognize. But if there are defects in the proceedings, that is another thing.
So he will eventually step down? Sigurado na he's going to step down?
I have not stepped down.
Yes.
Well, ano magagawa niya? What else can he do? But is the judgment already effective? Hindi pa namin tinatanggap Di ba? But in this positive portion.
Justice, you're not... So kailangan matanggap ninyo yung kopya of the decision?
And I do not subscribe to the view that it is immediately executory.
But Justice, what will happen, sir? If it's not immediately executory, what's going to happen?
Well, the 15-day period provided for under the rules will apply. Maybe the 10 or the 15-day period from receipt.
So what will happen within the 15 days?
Oh, I'm not very sure what period of time will apply in this process.
Sir, at this point, can you say how did you find the whole process? Was it fair?
I will not answer you, although I can answer you because we do not know what action we will take in connection with it yet.
Justice is going to the Supreme Court an option. Yeah, at this point.
How is that?
Is going to the Supreme Court an option right now?
No, it's not only an option. It is a right of an aggrieved party.
Okay.
Provided for under the Constitution to file a petition for review.
So you're not ruling out that option yet?
I cannot immediately rule that out because I haven't talked with my client. Even if I want to. Ayaw niya na.
Kailan kayo magpapile?
Correct. Very correct.
Kailan kayo magpapile, sir, ng Supreme Court ASAP?
Hindi pa nga kami nagkakausap ni Chief Justice. I do not know. Kung sa halimbawa, gusto ko, ayaw niya. Paano kami kukuha?
Pero kung kayo masusunod, ano nare-recommenda niyo sa inyong client?
That will depend on our assessment of everything. Dahil mahaba itong paglilitis na ito, hindi naman ngayon lang Ngayon, decision lamang. Now, we may not agree. But certainly we have to determine what possible legal action can be taken.
Initially, may nakita ba kayong tinatawag na grave abuse of discretion on the part of the senator judges?
Marami.
Like what, sir? Can you cite for particular instance?
Halimbawa, yung lamang na sila magtatanong, hindi kami maka-object. They can compel the production of anything. is that not derogatory to the rights of an accused?
Pero sir, yung explanation ng votes ng mga senator judges parang pare-pareho. May nakita ba kayong something orchestrated or script na ano?
Wala naman, hindi ko naman. Maybe,
So at this point, the Chief Justice...
Wala ko, dumating ka na pala.
Nakausap niyo na ba si CJ?
It was a great fight, and
Thank you. No, it was not a fight. It is a human endeavor, an excellent and magnificent one. And I'm heavily thankful that we were able to participate in it. History plus.
Sir, at this point, the Chief Justice is staying on, no? At this point, the Chief Justice is staying on.
Siya pa. Hindi pa naman ukan eh. Hindi pa.
Sir, right now, sir, aakit ba kayo sa Supreme Court? May decision bang ganun, sir?
Wala. Hindi ko pa nga siya nakakausap ngayon eh.
Yung sinabi is an option, sir.
So wala pa.
It's an option provided for by law, but whether we will avail it will probably depend on circumstances.
Yung sinabi niyo na 10 to 15, that's not immediately executory. Ibig sabihin, kahit binaba na ngayon ng Senado, hindi pa ibig sabihin he should step out of power?
That's my opinion. Ilang days na dapat, sir? Well, it's either 10 or 15. Ewan ko dito kay Senator. Tinatanong ko nga sa kanya, kailan ba? 15 ba? 10 or... Hindi pa kami nakikita.
How would you describe the whole proceeding, sir?
Ay, marami tayong frustration. Mahirap na. Baka sabihin naman, we are just sour graping.
Pero sir, you mentioned before kanina, no, na may mga nakikita kayo na grave abuse of discretion. Can you enumerate some of them?
I'll not do so unless we are already prepared our petition, if ever. If there is none, we have no reason to go up by way of certiorari.
So given that meron, sir, you will go up?
In all probability, yes, if the Chief Justice decides to do so. Because I cannot decide it myself. I wanted, for instance, I wanted to. Kung ayaw niya naman, how can we be able?
If it were
siya magiging petitioner, siyempre.
If it were call, sir, meron kayo nakita ng mga grave abuse of discretion, and kung ikaw yun, sir, akit kayo?
Yeah, kung meron. Kung we did.
chilling effect to the judiciary or to the critics of the government? May nangyari ngayon?
Hindi naman siguro. Depende kung wala ka namang ginagawang kasalanan eh. Kung wala naman nagawang kasalanan eh.
Hindi naman nakaka-apekto sa independence ng judiciary yung nangyari ngayon.
Paano natin malalaman yun? Ngayon lang nagkaroon ng decision. Hindi pa ako nakakalabas dito. I have not talked with anyone in connection with this. So I have no reason to make that kind of a conclusion.
So when do you think this will be executory, this verdict of the Senate?
Well, if we follow the rules on criminal procedure, it will be after 15 days.
During that time, the Chief Justice will stay on us.
Definitely yes. So, because kung hindi pa effective eh.
Sir, ano po ang pakiramdam ni Justice Cuevas ngayon?
Ano?
Ngayon po sa decision
natutuwa po ako at natapos na. Medyo makakatulog na ng mahimbing, makapagpahinga. But I'm also very, very sorry because I'll be missing you already. We'll not have the opportunity to be having this powwow and so on. And definitely, that is a great loss on my part.
Sir, kanina sabi niyo pag-aaralan niyo pa kung may grave abuse of authority. Ngayon ba, si
Hindi grave abuse of authority. Grave abuse of discretion. Oo.
So, ngayon for sure.
Hindi, titignan namin halimbawa yung mga nakaraang proceedings, yung kuhan ganito, and so on. For instance, meron diyang statement of account na hindi naman nila na-produce. In order i-produce, nag-order sila. That's the job of the prosecutor, not a member of the court.
Understudy ba? Pag-aaralan pa ng
Yes. Hindi naman tayo gumagawa ng basta tira, gawa file dito and so on. Hindi naman tama 'yun. Sapagkat kung mga minor lang yung complaint, it does not affect the rights of the accused to due process. Halimbawa, isang kwan, yung nagkaroon ng filing ng case, wala namang determination of probable cause. I made mention of that in my oral argument, that it denies the respondent of what is known as due process. And what does due process means? There must be a notice, there must be a hearing. Now, in their certification, yung naka-attach ako, they made no mention about having conducted that kind of a procedure.
Can we say the way that the Senate gathered some evidence? Can you say that can be one of the grounds, sir, for grave abuse?
That is not the job of the Senate. That is the job of the prosecutor. Wag na muna. Meron na. Oo. Itingnan uli kung yung aming recollection ay tama. Tingnan muna na yung transcript. Totoo ba ito? Sinasangayon na. If it is, and then we had...
Sir, pupunta kayo mismo kay Chief Justice Corona
Yeah, ngayon, meron kami. Oh.
Sir,
Pwede bang payagan na ninyo kami?
Sir, kayo ba, sir?
Sir, as it is, did you find fundamental reasons as you saw the
Ano yung,
whole event? No?
ano yung fundamental reasons as contradistinguished from ordinary reason?
Yes, sir. To appeal and to go to the Supreme Court. Did you find any reason?
Hindi pa nababasa yung decision, hindi pa nababasa yung kwan. Kung sabihin mong meron, that's unfair to the impeachment.
So it's still an option pero hindi pa alam kung
correct.
Pero Justice, may sama po ba kayo ng loob na yun?
Ngayon?
Sa mga senador po, sa paraan ng pagboto?
Wala naman. Yun ang conviction nila. In much the same way we have out on our advocacy, we have out on articulation and postulation. They are entitled to that.
Sir, yung
We may not agree with the way they dispose of the case, but decidedly, how could that be a correct source of sama na?
Is that acceptable or not acceptable on your part?
Well, marami kaming maaaring maging puna after going over it. Alam mo yung law, hindi naman basta ginawa, gusto mo, gagawin mo eh.
Did you see this coming, Justice?
Which one?
Itong 20 votes out of
20? Hindi namin sukat akalain. In fact, akala ko nung primero, tabla lang kami. Tabla lang.
And the battle is not yet over, no? The battle is not yet over.
For instance, kung halimbawa gusto ni Chief Justice na gawin niyang kung ano ayaw na kay Justice Cuevas, how can I give correct information to you? Hindi ko naman alam. Sige, kung sabi sige Justice, pag-aralan ko. And then he got another lawyer and so on. He will not be able to say what will be his next move.
Mensahe niyo po sa mga mamamayan na nanonood nito.
Ano pang mensahe ko? Hindi naman ako politiko. Ano tatakbo?
Sir, ulitin ko lang, sir, yun bang verdict acceptable or not acceptable to you?
Meron ba tayong magagawa na hindi natin tanggapin yan? Kung meron man tayong puna, the legal process must be followed.
So justice is not over yet, Justice?
Hindi ko alam kung ano sasabihin ni Justice Corona.
At ngayon po, pakinggan natin ang pahayag ni Senador Bongbong Marcos.
We are expected to be intelligent, experienced, and politically savvy. And because of that, it is left up to us to make those discretionary decisions.
Dapat tanggapin na lang ni CJ Corona, wag na lang niya i-question time decision sa Supreme Court.
Well, siguro kung nais niyang subukan na pumunta sa Supreme Court, pero sa aking pananaw ay itong impeachment court, wala nang ibang korte kahit ang Korte Suprema ang pwedeng mangibabaw dito sa impeachment court basta't sa kaso ng impeachment. Hindi, dahil may suggestion nga siyang ganun. Ngunit kung maalala ninyo, ang tawag dito ay impeachment trial. Kung siya ay convicted o hindi. At siguro meron ding posibilidad na iba ang magiging parusa. Pero ang napag-usapan lang namin bilang Senator Judge ay yung pag-impeach at pagtanggal ni CJ sa trabaho. Sa kanyang tinatrabaho.
Sir, ba't hindi na nabanggit ni Senator Enrile yung penalty?
Yung
penalty, sir, na
dahil hindi na question yung penalty eh. Maliwanag na sa amin lahat na it will be removal from office. Okay? Okay na? Ayos.
Yan po ang naging pahayag ni Senador Bongbong Marcos. Kung maalala ho natin, ang boto ho niya ay acquit. CJ Corona. At sinabi niya, nanindigan siya na dapat yung impeachment court yung mga ibabaw at hindi na siguro dapat umakyat pa ito sa Supreme Court.
Sa kayo, linawin ko lang kay Dean Agabin kay Professor, yung sinasabi ni Justice Cuevas na hindi pa nila natatanggap. So, wala pang pinal dito sa prosesong ito dahil nagbaba ng hatol at kinakailangan ng matanggap yung hatol ng nasasakdal, di ba?
Hindi raw immediately executory.
Masyadong technical siguro yung pananaw na yan, Igan. Kasi andyan nakaupo si Justice Cuevas noong bumaba ang decision ng impeachment court. Kaya from that moment on, considered na natanggap na.
Hindi kailangan matanggap ng kliyente.
ang pagtanggap ng abogado ay equivalent sa pagtanggap din ng kliyente. Kaya dapat na-consider na natanggap na.
Aha, okay. Kasi sinabi niya may 15-day period pa siyang hinihintay at pag-uusapan pa raw nila ng kanyang kliyente kung iakyat nila ito sa Supreme Court.
Hindi ko alam kung saan galing yung 15-day period niyan. Apparently from the
regular court.
Criminal case.
Correct. That's right,
regular
no? Doon sa mga sinasabi ni Justice Cuevas, hanggang ngayon, parang ang kanyang stand is this is a criminal proceeding. One, this is a judicial proceeding, and second, this is a criminal proceeding. I think naayos na yan nung umpisa pa lang na hindi. But I think that's a stand he's taking.
Okay, may isa pang nakakaintrigang usapin dito tungkol sa disbarment. Hindi lang pala removal from public office. Lumabas dito sa naging pahayag ni Senator Coco Pimentel na may disbarment pa siyang pinag-uusapan. Is that a possibility?
Yes, indeed it is. It was a suggestion. Parang hindi lang dapat maalis sa trabaho, kung hindi matanggal sa pagiging abogado or madisbar.
Anong dahilan naman po?
Marami ang grounds for disbarment, no?
Pero hiwalay ng hearing yun, no?
Iba yun. Iba
Pero
yun.
mayroong kasing ruling ng Supreme Court, Vicky, na yung mga lower court judges na natanggal sa position nila, sabi ng Supreme Court, dapat ma-institute na rin yung disbarment proceeding as lawyers. Ang pag-institute ng disbarment proceeding sa mga lower court judges almost automatic sabi ng Supreme Court
Okay.
Kaya ayaw ko kung anong gagawin nila dito ngayon kay Chief Justice.
Sige, I'm trying to look into the mind of Chief Justice Corona right now, what he must be feeling. Pero do you think, looking back, ang iniisip niya, dapat nag-resign na lang ako? But before you answer that po, eto ho, makibalita po muna tayo kay Sherry Ann Torres. She, kamusta?
Sherry Ann Torres. She?
Okay. Hindi campaign manager, hindi rin talent manager.
Talent manager. Sino yan?
Hello? Yes, Vigan.
Go ahead.
Yes, sa ngayon kasama natin si Cavite Representative Joseph Abaya. Siya yung nagsisilbi na manager nitong impeachment or prosecution panel. Sir, first lang, initially, ano yung naging experience? How was it listening to the votes rendered by the senator judges?
Well, for me, it was I guess hopefully once in a lifetime opportunity to go through and manage a team, a dedicated team with one clear vision of getting a conviction for the accused or the Chief Justice. We had our crest and troughs. Pababa may moments of jubilation, may moments of pain and of disappointment, but all of that all contributes to one's being of character and experience, and hopefully we learn from all of this, and at the end of the day, the biggest accomplishment here is to raise the bar for public servants, that there is indeed much expected for people given such power and responsibility.
Was it a difficult legal battle, sir, especially given the presence of these lawyers, veteran lawyers?
Should I say legal? It was a difficult and challenging experience. Managing a team of congressmen, handling media, of course, with the defense panel also around. So my initial task was really merely to brew coffee, tagatimpla ng kape. That's an all-encompassing description of the job of getting the team, the wheels turning, and things running smoothly.
Igan, may tanong kayo kay Congressman Abaya?
Siguro, ano yung naging turning point para sa prosecution, sa trial na ito?
Hello?
Hello? Yes, Attorney Abaya. What do you consider the turning point in the trial which turned the tide in your favor?
I guess when the real turning point, ironically, is when the defense started their key witnesses, and they ended up doing us a favor, especially with the Ombudsman and the Chief Justice themselves. So, as people have said, God indeed works in wondrous ways. I think those were the turning points.
Kasi nung sinimulan nyo itong impeachment trial na ito, hindi nyo pa na-factor in itong naging testimonya ni Ombudsman Morales. It just came later, much later.
Definitely not, because those were triggered by other intervening events. No, it was not part of it. Although the data that we have wanted were produced by the Ombudsman, no, we didn't foresee that the Ombudsman would later come out.
Okay, yung cross-examination, I heard hati raw yung grupo nyo kung i-cross-examine nyo ba itong si CJ o hindi. Was that
well, sa aking pananaw, no. We anticipated that question to be asked. There was a clear decision made that when he went to the floor, there was no hesitation. From my end, no, it was a clear decision prior to it happening.
Okay.
All right.
Congressman, si Arnold Glavi po ito. May aral ba ang natutunan ng House dito? Particular doon sa mga ilan din na bumoto ng guilty, pero pinuna din yung inyong proseso ng masyadong namadali o hindi nasunod yung ibang mga sub-judice clause ng impeachment court, Congressman?
Well, hindi po kami mapupuna dun sa one-third vote dahil malinaw sa ating saligang batas, yan po ay bahagi ng mga proseso sa impeachment. So, tingin ko hindi po babaguhin ho yun. At habang nandyan sa saligang batas po yan, ay mananatiling option ho yan sa impeachment.
Yung pagmamadali? Yung...
No, the one-third option vote.
Ng Kongreso, yung kung may bilang na majority, no? At itinatadaan sa preliminary investigation.
Tingin ko, hindi naman kami nagmadali. Sumangayon din kami sa nararapat sa saligang batas. So, okay lang po yun. Okay lang po yun.
Alright, sang-ayon ba kayo na mag-file pa ng mga criminal case laban kay Chief Justice?
Hindi ko wala na sa mandato namin yun.
But would you support something like that? Are you of the thinking na kailangan kasuhan pa ng criminal cases?
Well, kung nararapat, if there's sufficient evidence and probable cause would be proven, then it should be pursued. That is all part of judicial reforms and accountability and true justice as shown at demonstrated in a country that it should distinguish between the less privileged and the really privileged.
Okay. Congressman, wala na si Mercedes Gutierrez, wala na rin si Chief Justice Corona. Sino susunod nyo?
Hindi ko masasagot to yan. Hindi ko po alam.
Okay.
Okay. Sige. Maraming salamat po sa inyo, Congressman Abaya. Thank you. Okay.
Okay na.
Siguro balikan natin yung tanong ko kanina.
Ayan.
Should he have resigned? Yun ba iniisip niya, dapat nag-resign na lang ako?
What for? Umpisa pa lang, kitang-kita natin, ilalaban niya to. Pero dahil ganun nga yung kanyang determination, adamant siya na wala siyang ginawa at ipaglalaban niya to, alam mo, hindi malayo na yung plano ni Justice Cuevas, baka mangyari. Diba?
Yung dudulog sa Supreme Court?
Correct. He can do anything. But whether magpo-prosper yun is another thing.
Dahil wala pa naman tayo na unang kaso kung ano mga nangyari.
Right.
Tsaka mukhang hati yung depensa, no?
As far as that concerned. Meron nang nakapending na kaso sa Supreme Court.
Correct. Hindi pa na-decision.
Kailangan lang gawin ni Justice Cuevas kung gusto niyang i-pursue yung review, magpa-file ng supplemental petition doon sa nakapending na kaso sa Supreme Court.
Okay.
Kaya pwede po niyang maihabol yung supplemental petition.
With this guilty verdict, may natitira pa bang option kay Chief Justice Corona to save his face or to clear his name?
Yun na lang ang available option na maiisip ko.
Yung tumakbo sa Supreme Court?
Oo.
So hindi open pa rin yung clause na with finality, yung decision ng impeachment court?
Ay, hindi. Klaro naman na hindi na talaga appealable itong kaso nito.
Ano yung pwedeng itakbo sa...
Hindi. Meron pang may kaso doon na hindi pa nadidesisyonan. Remember yung petition? Questioning the jurisdiction of this Senate sitting as an impeachment court. Pero may nakikita pa akong face saver.
Ano pa yun?
This is nothing to do with the law na. Nakita natin kung paano during his opening statement, nung umupo siya, how he was effective to the people nung start nung kanyang opening statement. Marunong pala siyang kumausap sa sa publiko. So the last appeal kung para sa kanya is to the public para para kung ano man.
Okay. In other words, pwede siyang tumakbong senador.
Pwede ba siya tumakbo?
He wants to be vindicated.
Di ba perpetual disqualification
yun.
Public office?
But can he run in the 2013 elections?
Oo nga,
yun ang pinakamalinaw na parusa kasi sa impeachment court, yung perpetual disqualification. Kaya yun yung contention ni Justice Cuevas na seryoso to, wag nating Okay, manatili mo nakatutok dito sa GMA News TV.
Magbabalik pa rin po ang The Chief Justice on trial.
Inaprubahan na ng DOH ang ampalaya upang makatulong sa pagkontrol ng diabetes.
Lahat tayo inaasahan ng ating mahal sa buhay, kaya't pag-exercise, kumain ng tama, huwag magpabaya at mag-ampalaya plus araw-araw. Numero 1 sa akin.
Celebrating 1 year of broadcast excellence and leadership. GMA News TV, Channel 11.
Lahat tayo inaasahan ng ating mahal sa buhay, kaya't pag-exercise, kumain ng tama, huwag magpabaya at mag-ampalaya plus araw-araw.
Ito'y may sangkap na ampalaya, panaba at luyang dilaw.
Mag-ampalaya plus, maaasahan, numero 1 sa akin.
Nagbabalik po special coverage ng GMA News TV sa naging hatol po ng impeachment court laban kay Chief Justice Renato Corona.
At balik muna tayo sa ating diskusyon. Kasama pa rin po sina Dean Pacifico Agabin at Professor Rowena Daroy Morales.
So medyo madilim yung future ni Chief Justice Corona. Mawawala yung mga benepisyo, may mga pending cases na hiwalay nga. Sabi nyo nga, yung disbarment o criminal and civil and administrative. At wala na siyang makuha mga benepisyo.
But if he had resigned,
iba yun.
Hindi pwede siya tumakbo sana.
Kasi may record na yung pangalan niya, guilty. Na-convict na siya ng impeachment court.
Kaya nga, ang available option sa kanya ay gana yung review by the Supreme Court.
Territory naman niya yun.
Mayroong provision ng Constitution that the Supreme Court can check grave abuse of discretion on the part of any branch or instrumentality of the government.
Yan yung tinatawag nating certiorari.
Certiorari.
Yan yung tinatawag nating certiorari. Hindi yan appeal, ha? Hindi yan sinasabi nating yung decision inaapila.
Ano yung certiorari na yan?
Yung certiorari, humihingi ka sa korte
paglilinaw
ng hindi paglilinaw. It's an independent, it's a case by itself. It's a special civil action na by itself yan. Tinatanong mo sa korte ng relief dahil may nag-abuso na isang tribunal. Ano yung tribunal na yon? Etong Senado. Yun ang sinasabi na availability ng isang remedy. Kung gusto nilang... Pero I'm not sure if
bakit June 19? Bakit June 19 pa? Hindi ba pwedeng i-fast track at gawing mas maaga itong pagdinig?
Maraming pending case doon
Iba yun, ha? Iba yung June 19, ha?
Okay.
Actually, parang appeal na rin yun. Although yung mga abogado gusto nilang gumagawa ng mga distinctions between appeal and review.
Palusot na naman yan.
In effect, appeal din yun.
Appeal din.
Pero the Chief Justice will now have to prove that the Senate Impeachment Court acted capriciously, arbitrarily, or vindictively against him. It is difficult to prove.
Talagang appeal ng appeal ang pinag-uusapan natin. Ang sa akin, lumakas ang appeal ni Juan Ponce Enrile dahil I think he must be commended.
So hindi pa tapos ang ating special coverage? Hindi, tapos na yan. Okay, maraming salamat, Vicky.
Alright, maraming salamat sa ating legal expert na nakasama natin ngayong hapon, sina dating UP Law Dean Pacifico Agabin at UP Law Professor Rowena Daroy Morales. Maraming salamat po sa panahon na ibinigay niyo po dito sa impeachment trial. This is history.
Yeah, salamat sa pasensya. Okay, mga igan, inyong nasubaybayan ang pagtutok ng GMA News TV sa makasaysayang paghatol po ng guilty verdict sa kasong impeachment laban kay Chief Justice Renato Corona.
Mula po sa buong puwersa ng GMA News and Public Affairs, marami pong salamat sa inyong pagtitiwala. Ako po si Vicky Morales.
Ako naman, Arnold Glavio. Susunod na po ang Balita Pilipinas Ngayon kasama sina Maki Pulido at Mark Salazar.
Naging bahagi ka ng makasaysay